Good morning. Welcome to the Board of Registered Nursing Board meeting. It is June 20th, 2024, and we will take roll call to establish a quorum. My name is Dolores Trujillo. I am an RN, and I have been appointed by Governor Newsom to serve in the direct care provider role, and I am the current president of the board. Jovita Dominguez?
My name is Jovita Dominguez, and I was appointed by Governor Newsom, and I am the chair of the Education and Licensing. Thank you.
Thank you, Jovita. Board member Patricia Nguyen?
Hi, Tricia Nguyen. I was appointed by Governor Newsom into a public member role.
Thank you, Patricia. Board member David Lawler?
Good morning, David Lawler. I was appointed by Governor Newsom, also in a public member role.
Thank you. And we have on webcast, Board Member Vicki Granowitz.
Vicki Granowitz, appointed by Senator Tony Atkins and a member of the public.
Thank you, Vicki. Board Member Neelu Patel.
Good morning, Board Member Neelu Patel here, appointed by Governor Newsom for the advanced practice role.
Board Member Allison Cormack.
Good morning, Allison Cormack. I'm a public member of the board appointed by the Speaker of the Assembly.
Thank you. Our Executive Officer of the Board, Loretta Melby, sorry.
No worries. It's also Lori. I've been called others. So I am Loretta Melby. I'm the board's executive officer, appointed by the board. I just did want to make one announcement. I am remote today, as this was supposed to be a committee meeting, which allows for remote participation. And I am currently in Utah at a National Council of State Boards of Nursing conference. So I am in a secured location. There is nobody in the room with me, and I'm able to participate remotely. Thank you.
Thank you, Lori. And our Board Counsel, Reza Pejjuhesh.
Good morning, Board Counsel Reza Pejjuhesh.
Thank you. Our quorum has been established. BRN Moderator, can you take us to items 2.0 and 3.0, please, on the agenda?
Good morning. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the board reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. We also have a physical location, the DCA hearing room, and we will query that room for questions from the public as well in the same, how can I say this, in the same, oh, I'm having a brain cramp. I will ask, how is that? I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then proceed to the next member of the public who has a comment. I'm hoping somebody there in the hearing room will have a timer on physical questions. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. When your turn comes, you will be prompted to unmute. If your question can be answered, the board will respond accordingly. When making your comment, speak about anything you believe is important for the members to know. Remember, board members cannot address any item not on the agenda. Items not on the agenda at that moment, items that you would like to add to a future meeting, or items that will be discussed later on in the agenda will be discussed at their correct times during the meeting. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when board members or BRN staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will mute your microphone automatically. We will be opening for public comments now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Jacqueline Winters would like to make a comment. 1 second, please. Go ahead.
Bill that's going to be discussed this morning. I'm not quite sure if this is the appropriate time. 7?
Ms. Winters, we can't. Can you ask that again?
Oh, I'd like to make a comment regarding AB 3127, the legislation we're discussing later this morning. Is this the appropriate time?
No, it is not. Once we open up agenda item on AB 3127, we will ask for public comment around that, and that is the time to speak on that agenda item.
Excellent. Thank you and apologies.
Thank you, no problem.
I'll just add that's item 6.0 on the agenda.
Thank you. Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in the hearing room?
There appears to be no requests here for public comments.
Thank you. Would you like me to close this window?
Yes, thank you. Okay, moving on to item 4.0. This is discussion and possible action regarding board approval of board member Granowitz participating in board meetings from a remote location.
This is.
Thank you, and I'll actually turn that over to Reza for that one. I know that it says it's requested by me, but we'll let Reza speak on that.
Sure, thanks, Lori. So I'll speak to this briefly and kind of what this is. So under the Bagley-Keene Open Meeting Act, as most everyone knows, there are requirements about conducting these meetings in public and very specific requirements about having a certain number of board members in person versus remotely and all of that. The specific provision under which we are conducting the board meetings is Government Code 11123.2, which outlines those parameters. And it requires that we have a majority of the board members physically present in person. It does contain an exception to that allows a board member to participate remotely and still be counted towards that majority that's required to be in person. And that majority is it can be logistically sometimes an issue to ensure that we have enough. So I think that's part of the motivation here. So the code provision that I mentioned allows an exception that would allow a board member to participate remotely and still be counted towards that majority if they have a disability that would prevent them from participating in person, and it requires board action to approve that exception. So what we're asking for is for board member Granowitz to be able to participate remotely under that provision and be counted towards the majority. That provision requires the procedure outlined there for this requires a brief description that does not require board member Granowitz to disclose any medical diagnosis or disability. Doesn't need to be any more than 20 words. Does not need to disclose any personal medical information, but just a brief description of it, and then the board would need to vote and take action to approve that. And I think the request is for meetings going forward from this point. So unless there's any questions.
Any questions or comments from board members? No? Go ahead, Nilu.
Just one quick comment. Just wanted to say that Board Member Granowitz is an extremely valuable member of the board, of course, as we know, and I just support her in her health, so.
Thank you, Nilu. Any other comments or questions?
Dolores?
Yes.
It's Vicky Granowitz, and
Hi.
if Loretta is flying, and she can accompany me, then I will come and be on site. I just have limitations with mobility, and so I can't fly by myself.
And I have gracefully agreed to do that. We are both primarily located in San Diego. So when I am present to travel for board meetings, when they're not these additional board meetings, then I will gladly accompany you on the flight up and your return flight, Vicky.
Thank you.
You're welcome.
Thank you, Lori and Vicky. If there's no other, go ahead, Reza.
Sorry, Vicky, I hate to ask, and I think at a previous board meeting, you did speak a little bit about the condition that, underlies this. Do you mind just kind of repeating again, just minimally?
Yeah, I have multiple sclerosis, and that affects a number of systems that make travel difficult. I can't be unattended. And when Mary Fagan was on the board, she lives also in San Diego, and she could assist me with traveling. But I cannot travel by myself related to my disability.
Thank you.
If there's no other questions or comments, I think a motion is in order.
I'll make the motion if you'd like.
Sure.
Thank you. I'd like to approve Board Member Granowitz participating in board meetings from a remote location.
Thank you, Chair
Second,
Fay.
this is Board Member Cormac.
Thank you, Allison. BRN moderator, can you please open it up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in the hearing room?
No, there are no public requests for comment here in the hearing room.
Thank you. Would you like me to close this window?
Yes, thank you. All right, we'll take it to a vote. Dolores Trujillo votes yes. Board Member Allison Cormac,
Cormac, yes.
Board Member Jovita Dominguez,
Dominguez, yes.
Board Member Patricia Nguyen,
Win, yes.
Board Member Nilu Patel,
Patel, yes.
Board Member David Lawler,
Lawler, yes.
and Board Member Vicky Granowitz.
Granowitz, yes.
All right, thank you. Moving on to item 5.0, discussion and possible, this is a discussion and possible action. This is for appointment of a subcommittee to select and nominate members to the Nurse Practitioner Advisory Committee and Nurse Midwifery Advisory Committee.
Yes, thank you, Dolores. So Nurse Midwife Advisory Committee and the Nurse Practitioner Advisory Committee has provisions that the members of both of those committees will be appointed by the board. When we established those, the board had made a motion and formed a subcommittee of Michael Jackson and Elizabeth Woods to appoint the members of the Nurse Practitioner Advisory Committee. And the second subcommittee was Dr. Mary Fagan and Dolores Trujillo, who was the subcommittee for appointing members of the Nurse Midwifery Advisory Committee. And once the applications and stuff were reviewed and examined, they would bring their recommendations to the board, and the board would then vote to either accept or amend or et cetera. As you guys are aware, as our current board members, Michael Jackson, Elizabeth Woods, and Mary Fagan are no longer board members. Therefore, we do not have any current subcommittees to partake and do this work. And so I am asking if the board would consider appointing the administrative committees going forward to serve in this role. The reason that I ask for that is that committee does meet on a regular basis. I am the one that filters the information through to them with the help of our Chief of Licensing, Macaulay Fusarens, who serves as the liaison. And that can help expedite the process. It also aligns us with the way that the appointments are made with the Clinical Nurse Specialist Advisory Committee, the Certified Registered Nurse Anesthetist Advisory Committee, and the NEWAC Advisory Committee, where each one of those are accepted through the administrative committee and then presented to the board for final ratification of that. And so that would help to align that process. So that is the consideration. We do right now have a current vacancy in the Nurse Midwife Advisory Committee. And then I do have some news that I would like to share out. I was noticed by Elizabeth Brown. She's a clinical nurse specialist on June 6th, that our public member for the Clinical Nurse Specialist Advisory Committee, Angelique Ellenbow, did pass away on June 1st. And so just wanted to say my condolences out to her and her family and her friends. And thank you again, Alyssa, for letting us know. Alyssa was gathering information for us, and we did, when we receive an address and stuff, we will be sending out a card and some flowers just to kind of represent some of our deep felt sympathy and gratitude for her participation with the CNSAC committee. So as you can tell, there are times that we do have to have these kind of impromptu re-advertising and appointments, and to have an active subcommittee working on those, that would be helpful. So thank you, guys.
Thank you, Lori. Our condolences from the board goes out to the committee member that passed away and their family.
Thank you.
Any questions or comments from board members? Board member Allison Cormack.
Thank you, Chair Trujillo. I believe we also have an opening, though, on the admin committee. Isn't that right? So the
Yes.
admin committee is currently just the chair and the executive officer.
At this point, we are scheduled to have that at our regularly scheduled board meeting in August, where we will do appointments and also reappoint a board president and reappoint a board vice president. That is done on an annual basis. And the August board meeting is the time that that does occur. So anytime the admin committee changes, which is on an annual potentially on an annual basis, those members would change. And that's why we asked, instead of appointing specific members, to appoint to the admin committee, which would be anybody that fills that role.
Okay. It makes sense to me that we have this process now that these committees are established, be aligned with the other replacement procedures. Thank you.
Thank you. Board member Tricia Schoen.
Thank you very much, Madam Chair. So once the admin committee selects and nominates members, who then appoints them? Is that a board or is that the advisory committee?
It's the board then. So once that admin committee does the review process and selects some candidates that would be eligible for this, they would then we would itemize a board agenda item, and it would come to the board. The admin committee would say why they selected these people, answer any questions that the board members might have, and then you guys would either ratify that by voting it and saying, yes, we agree, or suggesting a change, and then they would go back out and re-recruit.
Great, thank you very much.
Thank you, Patricia. Any other questions or comments from board members? Any questions or comments from Vicky? Okay. So at this time, I would like to make a motion. I would like to make a motion to approve the appointment of the admin committee to select and nominate members to the Nurse Practitioner Advisory Committee and the Nurse Midwifery Advisory Committee.
I second David Lawler.
Thank you, David. BRN moderator, can we please open it up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in the hearing room?
There are no requests for comment here in the hearing room.
Thank you. Would you like me to close this window?
Yes, thank you. Okay, we will take the motion to a vote. Board Member Allison Cormack,
Cormac, yes.
Board Member Jovita Dominguez,
Dominguez, yes.
Board Member Patricia Nguyen,
Win, yes.
Board Member Nilu Patel,
Patel, yes.
Board Member David Lawler,
Lawler, yes.
and Board Member Vicky Granowitz.
Granowitz, yes.
Thank you. Oh, and Board Member Dolores Trujillo votes yes. Okay, we're moving on to item 10.0. This is the report on legislation. And I am the chair, Dolores Trujillo, of the Legislative Committee. And Marissa,
Good morning.
thank you, Marissa.
Thank you. Morning, board members. Marissa Clark, Chief of Legislative Affairs. We have about 7 bills today. A handful are ones that were on the previous board agenda and we didn't have time to get to all of them. And then there's a couple new ones. So the first one we're going to start off with is Assembly Bill 2269 by Assemblymember Flora. Just some background. Current law states that public members who are appointed to a board under the Department of Consumer Affairs cannot currently or within 5 years prior to their appointment have had an employment or contractual relationship with a licensee of the board unless that relationship constitutes or did constitute no more than 2% of the overall practice or business of the respective licensee. So this bill would make 2 main changes to that requirement. First, it would reduce the existing timeframe during which public or lay members of a board are prohibited from having business relationships with licensees of that board from the current 5 years down to 3 years, immediately preceding the board member's appointment. And second, it would remove the allowance for up to 2% of a licensee's practice to result from a board member's business relationship with the licensee. And the bill does also specify that these provisions would only apply to any board appointments or reappointments that occurred after this bill went into effect, so January 1, 2025. Happy to answer any questions.
Any questions or comments from the board members? Board Member Allison Cormack.
Thank you, Chair Trujillo. Good morning, Ms. Clark. Do we have any sense about why this bill has come forward? Well, let me step back. How long has this 5-year provision been in place?
My understanding is that these provisions have been in place for quite some time. Let me pull up. I want to say it's since potentially the 60s. It hasn't been like substantively tweaked.
Okay.
There's been a couple tweaks here and there, but they are fairly historic language.
And so what would be the impetus for moving it from 5 to 3 years?
That is a good question. I haven't been able to discern the 5 to 3 year specifically just from the author statements and like the committee analysis and whatnot. Around the 2%, there was some language or some discussion that the way that the 2% is written, the time and the kind of paperwork it takes to like get business records and whatnot and verify that 2% is a fairly burdensome process. So that may be kind of taking more effort than is worth. In regards to the 5 to the 3%, I had heard some that it kind of tempers by reducing the 2% one place and then or removing the 2% and then reducing the 3%, they kind of cancel or each other out. But there's nothing super clear that I've been able to find that states, here's the kind of basis for it.
As a member of the public, I guess I would be concerned about the perception and then potentially the possibility that someone who was in a particular industry would then have a much shorter period before they were able to participate and would presumably bring all those relationships and interests with them. So I don't, in terms of protecting public interest, I'm unaware of a reason that we would want to support this.
Thank you. Board Member Patricia Nguyen?
Thank you very much. I share Board Member McCormack's concern. As a public member, I see the value of public member. I see the value of not having ties to the industry. I was just wondering if you are aware of what the opposition from the Consumer Protection Policy Center at USD is.
Yeah, so according to the committee analysis, they were concerned that such a change could erode public protection in board decisions and talk about public members playing a crucial role in the DCA boards, and public members by their very nature help further this goal and prevent decisions made solely by the licensees who seek to regulate their own profession. So I think just maintaining the.
I share that concern, and I kind of align my interests with that argument. So thank you.
Any other questions or comments from board members? Any questions or comments from Vicky Granowitz? None? All right.
I move that we oppose this bill. I don't know that there's anything that we could tag on as an amendment that would alleviate my concerns.
This is Board Member Cormack, and I will second that motion.
Thank you. We have a first and second. At this time, we will move through the bills and the motions, and at the end, we will open it up for public comments.
Can I ask for a reconsideration, please? I've been contacted by several people to have public comment take place after each bill.
Okay.
So if board president, you would reconsider,
Yes.
that would help to manage the stakeholder feedback.
Yes, thank you.
Thank
All
you.
right, Mayor and moderator, can you please open it up for public comment?
We'll be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in the hearing room?
We do not have any public requests for comments here.
Thank you. Would you like me to close this window?
Yes, thank you. All right, we have a first and a second. We'll take it to a vote. Dolores Trujillo votes yes. Board Member Allison Cormack,
Cormac, yes.
Board Member Jovita Dominguez,
Dominguez, yes.
Board Member Patricia Nguyen,
Win, yes.
Board Member Nilu Patel,
Patel, yes.
Board Member David Lawler,
Lawler, yes.
and Board Member Vicky Granowitz.
Granowitz, yes.
Thank you. Thank you, Marissa.
Thank you. So the second bill is Assembly Bill 2862 by Assemblymember Gibson. Current law requires boards under the Department of Consumer Affairs to expedite the licensure process for a variety of groups. This can include veterans, military spouses, refugees, and asylees. The law also requires the Board of Registered Nursing, the Medical Board, the Osteopathic Board, and the Physician Assistant Board to expedite the licensure process for applicants who can demonstrate that they intend to provide abortions within the scope of practice of their license. This bill would additionally require all boards under the Department of Consumer Affairs to prioritize African-American applicants seeking licenses, especially applicants who are descended from a person enslaved in the United States. The bill would repeal its provisions on January 1, 2029. And happy to answer any questions.
Are there any questions? Okay. Board Member Allison Cormack?
Thank you, Chair Trujillo. Ms. Clark, what do we think prioritize would mean? We've seen expedite before, and perhaps Executive Officer Melby would also, and/or whichever of you would like to answer the question. I guess I'm trying to understand what prioritize would look like in our process and how that might affect other applicants.
In our process, it would look the same as expedite. We don't have a different definition for that. And so there is a question that is put on the Breeze application asking if they qualify. If they qualify, they mark yes, and then they submit the information that provides the documentation that qualifies them for any kind of priority or expedite. Then a report is pulled on a daily basis of all applications that have that expedite or priority check mark checked, I guess is a good way to put it. And then applications are opened up and processed accordingly. And then once those are processed, then it goes into the regular queue. The one issue that we have seen in the past with expedites and now language here that would say priority is if that application is pulled forward and reviewed based on that expedite or priority, and the documents that are needed to prove that are not received, then it is closed out and put back in queue. And so it's not a clean process.
And can you refresh our memory about how much more quickly expedited license applications are processed than regular license applications?
So it only allows that first review to be done faster. So it doesn't lead you necessarily to a license faster. It leads you to a first review faster. And I can only speak to our board on how that's managed. I can't say that that's the same for every other board and bureau. So with our process, because we do have specific out-of-state requirements and international requirements, which require us to review their pre-licensure nursing education at the level that we do, those documents continue to need to be supplied by the applicant. We also still require fingerprinting if they're able to travel into California before the license is issued. They can do that via live scan, which we typically have the results within about 3 days. If per the Department of Justice, the requirement is if you are outside of California, you cannot live scan. So you have to do a hard card fingerprinting where you go to like a police station and you roll each one of your fingerprints. And then that is submitted to the board, which is then submitted to DOJ. And that can take up to 3 months for that. So those items that are required for application are required for anybody, regardless of an expedite or not. So what this process does for our board is gets that initial review in quickly. we're able to then review that application, let the applicant know exactly what is missing, and have that communication start sooner so that they can then turn in those documents that are required for us to have for that to issue licensure. If for some reason, and this does happen occasionally, all documents are here when that review is done, we can issue a license on that initial review.
Thank you.
You're welcome.
Board Member Patricia Nguyen.
Thank you very much. I am definitely persuaded, looking at the numbers of the need for a bill like this. And because it doesn't seem terribly disruptive to our process, they get an initial review quickly. I mean, that seems very reasonable. The only thing that it kind of piqued my curiosity was, the bill requires boards under DCA to prioritize African-American applicants seeking licenses, especially applicants who are descended from a person enslaved in the United States, which absolutely I'm in favor of it. But how do we tell by checking a box if you're especially, in a position where you were descended from slaves?
Yeah, that is one area the law is silent in terms of to your point around the especially, and I think the prioritize, I would agree with you, Melby, that I think we would interpret that the same as just expediting, but it is silent on any type of documentation that may be required. Most of our other expediting do have something in the law or in the regs around you provide this type of documentation. That being said, I did try and do some research to figure out, okay, is there kind of a source or a reputable source where people can go to provide? And there's not one, as probably is not super surprising. I did find some data from the National Archives, and they had about 10 or so different options, but they even said that is a partial list. So on one hand, it doesn't specify exact documentation, but on the other hand, I think trying to specify that could potentially be a very long list, given that it's not as easy to go to one uniform site and get that type of documentation.
Thank you very much.
Marissa?
I'm supportive of the bill regardless. So thank you.
Thank you. And then Marissa, I know that you had shared with me that maybe other boards had suggested an amend, that it would be an attestation that would be accepted as the document that would need to be submitted. Therefore, a documentation would not be submitted. I don't know if that was, if we'd heard any more on that, if you wanted to share some additional information on that.
Yeah, I know there was one board who, in their suggestions in the first house, said that same reason of preferring there to be some type of attestation option, probably along the same lines of not wanting to not have a clear listing of the documents and then kind of inhibit the purpose of the bill. Let me go down and make sure I can pull up exactly who that was.
The reason that I ask board members is in implementation, right? And so if this passes, and I'm assuming we would get a full support from our board, I would need direction, and our licensing would need direction on what documents we could. Now, it is a DCAY build, so DCA would have some input on that, which is gratefully accepted. But I did want to make sure that we shared out that one of the boards or bureaus had made a motion to, I believe, approve with an amend. And that amend would be to allow for that attestation or that documentation to be done through an attestation so that we would not need to have any undue burden or any additional requirement put on these applicants that could potentially delay them or put them back into queue or some sort.
Yes, and it was the Respiratory Care Board who had provided that feedback on the bill. It was an oppose unless amended that they had taken. I'm not sure if it's still on record in this house, but the concern was around the time and expense it could be required to identify applicants as African American, especially determine if they are descended from a person enslaved in the United States. And so they were asking for amendment that would allow for self-identification of African American ethnicity by the applicant, as well as the inclusion of a provision that requires the applicant to provide evidence that he or she is the descendant. So it is a little bit of a both, one self-attestation, one providing some documentation. Yeah.
Any other questions or comments from board members? I personally I'm in favor of this bill, but I would like to see more clarification on what documents would be acceptable regarding the descendants of a slave person.
My-
I'm just curious.
So
Go
one
ahead,
of the
Lori.
things that has happened in the past is, say like when we have a bill that comes through and we put into law, when it is a DCA wide bill, they can work with all boards and bureaus to discuss a process around that. And then regulation would have to be implemented and then adopted that would say these are the documents that are required. So if it did get to a point where this bill goes through and say we just do a support vote, or if we do a support with amends and the amends that maybe we suggest are not accepted, and it does go through, that is not the end. So we would be able to work through DCA with DCA, to get some regulations in place to be able to have a possibility of accepting multiple types of documentation. And if our board decided in regulation that it would simply be an attestation, we do have that ability to do that as well in the regulatory process. So I just wanted to make sure that if this was an area that was not absolutely clear, we do have the potential to make this clear through the regulatory process in the future. But caveat, regulatory process always takes a year or two to make that happen. So that's a consideration as well.
Any other questions or comments from board members? I would like to make a motion to support if amended. And the amendment would be more clarification of what documentation would be required to expedite this process of licensing.
Marissa, is there a difference of support if amended or support with amendments?
Not necessarily. I think either would be, if the amendments aren't taken, then the assumed position would be a neutral.
Great, thank you.
Mhm.
I second David Lawler.
Board Member David Lawler. Thank you, David. Board Member Allison Cormack.
I wonder just, again, I'm still a little hung up on the word prioritize. I wonder if we might also suggest that they align the language with expedite. So we and other boards understand what's happening and other applicants don't feel that they are deprioritized. Would the maker and the seconder be amenable to that as a friendly amendment?
Point well taken. Thank you, Allison. Any other questions or comments? No? Any questions or comments from Board Member Granowitz? All right. We have a first and second on the floor. BRN moderator, please open us up for public comment.
Sorry, I may have missed. Was Allison's request incorporated into the motion for clarification on priority versus expedite?
The maker and the seconder both nodded, but I don't know that there was verbal
So,
agreement.
Chris and David, are you?
I'm
adding-
I'm in acceptance of her comments.
Yes, that's fine. I
Being
approve.
placed in the motion.
So the motion is to support this bill if amended to provide clarification on the documentation that's required and to change the word prioritize. to
Recommend,
expedite.
yeah, recommend changing the word prioritize to expedite to align with the current processes.
Thank you.
All right, BRN moderator, can you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give you reminders as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in the hearing room?
No requests here for public comment.
Thank you. Would you like me to close this window?
Yes, thank you. We will take it to a vote. Dolores Trujillo votes yes. Board Member Allison Cormack,
Cormac, yes.
Board Member Jovita Dominguez,
Dominguez, yes.
Board Member Patricia Nguyen,
Win, yes.
Board Member Nilu Patel,
Patel, yes.
Board Member David Lawler,
Lawler, yes.
and Board Member Vicky Granowitz.
Granowitz, yes.
All right, thank you.
Thank you. So the next bill is Assembly Bill 3127 by Assemblymember McKinner. Under current law, a healthcare practitioner who treats a person with a wound or other physical injury inflicted by a firearm or a wound or other physical injury that is the result of assaultive or abusive conduct must report that fact immediately by telephone and in writing to the local law enforcement authorities. Failure to do so is a misdemeanor. This bill would amend that provision to instead require a health practitioner to immediately make a report to a local law enforcement agency in the following instances. A person is suffering from a wound or other physical injury inflicted by a firearm. A person is suffering from a wound or other physical injury that is life-threatening or results in death caused by the use of non-accidental violence inflicted by another. A person is suffering from a wound or other physical injury resulting from child abuse or elder or dependent adult abuse. The bill would require that in the circumstance of an adult seeking care for injuries related to domestic, sexual, or non-accidental violent injury, if the patient requests a report be sent to law enforcement, then healthcare practitioners must make a report to the local law enforcement agency following the standard reporting process. The bill would not limit or override the ability of a healthcare practitioner to alert law enforcement to an imminent or serious threat to the health or safety of an individual or the public. The bill would also require a healthcare practitioner who is in their professional capacity or within the scope of their employment knows or reasonably suspects that their patient is experiencing any form of domestic violence or sexual violence to provide brief counseling, education, or other support and offer a warm handoff or referral to domestic violence or sexual violence advocacy services before the end of the treatment to the extent that it is medically possible. The bill states that if the patient is being treated in the emergency department of a general acute care hospital, the health practitioner shall also offer assistance to the patient in accessing a medical evidentiary exam, reporting to law enforcement, and a 24-hour domestic or sexual violence advocacy program if the patient wants to pursue these options. The bill would require health practitioners who treat a patient for wounds, physical injuries, or other signs consistent with abuse that have not previously been documented in the health practitioner's medical record for the patient to document such wounds, physical injuries, or other signs consistent with abuse in the medical record for the patient. And lastly, the bill would provide that the health practitioner shall not be civilly or criminally liable for any report made or not made pursuant to this bill, or for any other acts taken or not taken in good faith compliance with the provisions of this bill and other applicable state and federal laws. So as indicated in the analysis, the board has previously opposed two similar versions of this bill, one in 2023 and one in 2022. In previous discussions, the board discussed a desire to see still some type of incident report or documentation be completed and maintained at least internally, so that if a survivor chose not to access it at that point in time, they could still access it down the road if they chose to engage with law enforcement later on. This version has a provision requiring wounds, physical injuries, and other signs consistent with abuse to be documented in the patient's medical record, which appears to be a response to that request. In past years and discussions, the board also discussed the need for still having some type of ongoing data collection that would allow for essentially increases or decreases in the occurrence of domestic abuse incidents to still be tracked at some type of local, state, or federal level. And it does not appear as though the bill currently has language that addresses that item. So just some background context on previous discussions. Happy to answer any questions.
Thank you, Marissa. Any questions or comments from board members? Board Member Patricia Nguyen.
Thank you. You know, this is a very difficult bill. We've had it before us several times already. I'm always very torn because I think my values more align with the list of supporters than it does with the list of opponents, and yet I remain opposed to this bill because I worry about escalating domestic violence and, you know, a survivor of violence being too fearful to report. And so that's kind of where I am. I'm leaning opposed. I would value, you know, the opinions of other members of this board.
Board Member David Lawler.
I was also in strong opposition when this came out. I remember it a couple times. We've had to deal with it before, but I must say the changes made by Assemblymember McKinnon or their office are impressive, and I'm glad that they're addressing our concerns. So it has addressed my issues, and I appreciate the addition of how they're protecting not just the nurses, but giving the patient some authority to say which way they want to go. Not just saying this is our black and white protocol and it's weakened or taken the teeth out of what used to be. So unlike Member Nguyen, I am moved to support it in this condition.
Board
If I may,
Member
can
Allison
I- oh,
Cormack.
Sorry, I did not see Allison. Sorry. Thank you.
Board Member Vicky Granowitz.
I also am usually in alignment with the people that support this, but as a former psychotherapist who had a responsibility for reporting, I just think that it is black or white. And I think that it still leaves too much wiggle room, even depending on how the warm handoff occurs. It's very difficult to report, even when it's black and white. And I just think the reports, I think things will fall through the cracks even more. And so I will not be supporting this bill. I think there are some things that need to be hard and need to be black and white. And I think reporting this kind of violence is one of those things.
Board Member Allison Cormack.
I am aligned with Board Member Nguyen and Board Member Granowitz on this, and I appreciate that, you know, the victims' rights groups who believe that a better method might exist. But this is one of the few guardrails that we have in our society for identifying violence that is occurring and preventing it in the future. And while the justice system is an imperfect way to resolve these, it is the way that we have, and it does provide protections for that victim and any future victims. So I will be opposing this bill.
Is this now a good time for me to speak up, just because I know that I wasn't able to see that Board Member Granowitz had her hand up?
Go ahead, Lori, and then we have Neela Patel after you.
Thank you. So as shared in past board meetings when we had discussions around this bill, the main opposition last year was getting statistics, having the still process for the reporting to be done. I am very happy. Marissa and I did meet with the sponsors of the bill, and we shared with them that we were very happy that they did change that reporting process so that the documentation was still there. It is the same form that is used for reporting or not reporting. So there was no additional confusion or training that would have had to have occurred at the bedside where this is implemented. And I know that that was a concern our board had shared last year. And so I was happy to see that. And you guys are absolutely so correct. There is no process for collecting data still. And Board Member Granowitz last year had mentioned, how do we know if this works or how do we know if this doesn't work if data is not collected? And so there is a process out there that is not in this bill that I do want to share with our board members, and it is done through the sexual assault nurse examining or forensic nursing community that I used to be actively a part of. And from 2009 to 2014, just so that everybody has that background there, because I know we'll be hearing public comment, it's a non-incident report. And so when we get a person that has been victimized coming in to seek care, we give them the option. We say, we can do this examination for you, and we can turn this into law enforcement, and we can provide these types of services for you. We also give them the option that we can do the examination, collect the evidence, have everything here, have that report completed, and it is completely that person's choice. They get to choose their care. They get to choose whether or not this gets turned into law enforcement or whether or not this gets turned in to still law enforcement, but not acted on. And so with that non-incident reporting option, we would have sexual assault victims come in, get all of the testing done, receive the services. We would do a handoff to an advocacy group. I specifically worked with Centers for Community Service. The advocate was there during the entire examination that we performed. They got them a ride home. They got them clean clothes. They got them set up. They would then follow that person through any of the court hearing, et cetera, and provided an amazing service. So I do see why this group wants that advocacy done. It's that follow-up. It's that ability to go more out of just this acute setting so that the people that are experiencing this have avenues for support. So again, I understand that part as well. The part that I believe is still missing with this bill is turning this information into the police as a non-incident report. So that statistic analysis is there. The evidence that is collected is kept in a crime lab so that it can be kept under that chain of command, and it can be then utilized in future potential litigation or anything that happens with this. When you do not have that chain of command for the evidence that you collect as part of your examination, whether that be with the medical record where we take pictures and we document bruises and scrapes and cuts and tattoos and birthmarks, and whether or not any of that is documented right now, that goes into the medical record. That stays in the medical record. That doesn't come out of the medical record. This report that is written would go into the medical record and it stays there. And all of those other provisions happen where you do the warm handoff, and that's fantastic. But that chain of evidence is disrupted. And so that is where there's a concern, because that evidence would typically in a non-incident report get turned over and put into safekeeping in a crime lab. That additional reporting information where we report out to the state, we report out to the federal government on crime statistics. There are laws within our schools that say that you have to let your student know the crime statistics of your area. There's laws with renter laws and home buying where they have to report out crime statistics. If this documentation is not turned into law enforcement, those crime statistics don't occur. And then in Board Member Granowitz's point last year is, if this documentation is turned in as a non-incident report, we would be able to see if this works, because we'd have that documentation. We'd be able to show that violence has not increased, because we would still have that documentation going forward, just no law enforcement intervention. If this goes forward and we don't have that law enforcement intervention, we still have the documentation, we would then be able to show that in fact it increased because we didn't have the law enforcement intervention. So I think that data is key, because we won't know the effect of this bill without any data. And so that's the information I wanted to reshare that we had shared at our board last year, and I believe the year prior in these discussions. Thank you.
Thank you, Lori. Board Member Nilu Patel.
Board Member Patel here. I just wanted to thank EO Melby for that excellent explanation and clarification. And based on her experience, her extensive experience with this, I just wanted to add that, you know, I'm in alignment with our board members. And I think it's really important to be mindful that as healthcare workers are experiencing violence in the industry and it's increasing, communicating in a medical record that the abusee may be accompanied by the abuser informs the healthcare provider to also be on alert. And I think it's a form of protection for the healthcare provider as well. So I'm in support of it. I'm not in support of this.
All right. Any other questions or comments from board members? Any other questions or comments from Vicky Granowitz?
No.
All right.
So I move that we, the Board of Registered Nursing oppose AB 3127.
I will second. This is Board Member Cormack.
Do you guys want to do a direct oppose or oppose with amends? Just if you guys do amends, we're able to have additional conversations with the sponsor and the author as it moves through. If it's just a straight oppose, then we have to just kind of make that message.
Lori, I would say if it helps you, we could do a oppose with amendments, but I can't imagine an amendment right now that would move me from oppose. So maybe after public comment, I would feel differently, but I do want to make your life easier. I do think it's important that we continue to be engaged in the conversation.
Thank you. So if we don't want to do a first and a second, and I'm not sure if it was seconded, I apologize.
Yes, it was.
Yes.
It was, okay. So then we would just have to amend that motion if something were to change after public comment.
Okay.
Yes.
Yeah. I'm open-minded. Yeah.
All right. BRA moderator, can you please take us to public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Jacqueline Winters would like to make a comment. 1 second, please.
Good morning. My name is Jacqueline Winters Hall. I'm surprised that I'm back here the last 2 years. Can you hear me? I apologize.
Yes, you're going in and out.
I live very, very rural and our internet's not great. My name is Jacqueline Winters Hall. I am a registered nurse, public health nurse, and a forensic nurse examiner in rural Northern California. Our hospital is on the front line of crime in our community, and we take immense pride in the trauma-informed medical and forensic care we provide to our patients. In my role, I provide forensic medical exams for pediatric, adolescent, adult, and geriatric patients every day. Our emergency department, trauma team, and forensic nursing team provide care to these patients who are victims of criminal violence. We're in rural Northern California. We do not have a trauma recovery center. We do not have a family justice center. There are no resources for human trafficking. If someone calls the human trafficking hotline, they are told to call the police or come to the hospital. We have a dual certified domestic and sexual violence agency. They are wonderful. However, they are unable to provide in-person services to the hospital for domestic violence. They just started providing services January 16th of this year for in-person accompaniment for sexual assault. Prior to that, it had been in 2019 that we had in-person advocacy for sexual assault. We have been providing forensic medical exams by ourselves. without any support. Advocacy is woefully underfunded. There is no money in this bill to provide training for medical professionals or increase our advocacy options up here. Law enforcement is the one that has the ability to put patients up in motels. I also I had more to say about being rural and how underfunded we are and how awful this is going to be for our patients. But I wanted to thank you for your testimony regarding your experience as a forensic examiner. One correction is that this bill also changes that the forensic medical exam right now for sexual violence does not go into the medical record. It is a legal document. We document in Epic meds, labs, and if the patient required medical care in the emergency department, the injuries and the findings and the statements of the patient go on the forensic medical exam form, not part of the medical record. This bill, to me, I'm not a lawyer, I'm a nurse, but this bill looks like that forensic medical record with all of the injuries and the pictures of very intimate areas that are now protected and sequestered from the medical record will be part of the medical record. If a patient gets in a car accident, is the insurance company going to see their genital photos? That's extremely concerning to me. I have concerns on all levels.
Thank you for your comment. Casey Gwynn would like to make a comment. 1 second, please.
Hi, this is Casey Gwynn. Can you hear me?
Yes, go ahead.
Hi, I'm Casey Gwynn, the president of Alliance for Hope International, speaking in opposition to AB 3127 and supporting the motion just as it was made. I chaired the Attorney General's Task Force on Domestic Violence in California in 2005. The last time we looked at the suspicious injury reporting law, we recommended keeping it, but recommended some changes. Those changes were not pursued at the time. Since that time, there has been no comprehensive analysis of any state entity about the suspicious injury reporting law. This bill is based on anecdote, and we are terrified that more victims are going to die. The terrified victim who comes in who's been strangled, not a life-threatening injury, because the definition of life-threatening in this bill is likely to result in death. A strangulation victim can come in with a traumatic brain injury, a carotid dissection, serious injuries, and if she's not likely to die without intervention, it's not reportable. And by the way, nothing really is reportable under this current bill because they've taken out all liability. There's no liability, civil or criminal, for reporting or not reporting. And there's no sanction if you don't do the warm linkages, the referrals, the handoffs. What they're expecting emergency room trauma nurses to do, especially in busy centers, is going to become a piece of paper. And terrified victims are going to walk out with a piece of paper. Right now, we have 30 family justice centers in California. Those forms, those medical mandated reporting forms, go to the Family Justice Center and advocates follow up with victims in those cases. We need those forms. We need that reporting so we can reach out and offer services. Survivors always have the choice to choose not to participate with law enforcement at any time. And we choose, in this case, to completely oppose this bill and urge you not to negotiate. We've tried for 2 years to negotiate, and the supporters will not negotiate a reasonable compromise.
Thank you for your comment. Tim Walker would like to make a comment. 1 second, please. Kim, on your computer, somewhere behind a window is an unmute button. If you have many windows open, you'll see a window that says unmute me. There you go.
Can you hear me?
Yes, go ahead.
Oh, there you go. Okay. Good morning. My name is Kim Walker, and I am a licensed registered nurse in California. I've also been a sexual assault forensic examiner for the last 20 years. Just a little bit further from Ms. Melby, SAFEs do provide the trauma-informed medical care and forensic evidence collection for survivors of sexual assault, domestic and intimate partner violence, strangulation, and abuse across every age group, all of which have seen an increase over the last several years. I also serve on the executive leadership board for CalSAFE, which is the California Sexual Assault Forensic Examiners Association. We represent the 49 SAFE exam teams currently active in California. We are dedicated to providing the highest standard of medical forensic care and ensure our patients are supported, believed, and safe. We also are specially trained to document and collect the objective evidence, both medical and forensic, of harm done to survivors. And these actions are critically important tools, both for the health care of the patient and for any potential civil or criminal liability that they choose to pursue. And also, we want to make sure abusers can be held accountable when the survivor chooses to move forward. CalSAFE strongly opposes this bill as written. We do agree that the relevant penal code sections for mandated reporting do need to be looked at, amended, and center the patient in all of the decision making. But this bill as written is a dangerous overreach. We feel that it will create confusion and unintended consequences in its implementation. We are concerned about the places that it doesn't address. Particularly, it will impede healthcare providers from acting in cases where they have grave concerns of the patient's ongoing safety. It will make it optional for healthcare providers to report to law enforcement, regardless of the severity of injury. It will actually leave survivors without support of trauma-informed in-person advocates in many cases, and it will leave the highest risk vulnerable to their abuser. It also will negatively impact the current processes for SAFE exams teams to be able to respond, because the mandated reporting is a key element for patients getting to us so that we can provide our exams. So if passed, we are concerned that this will further roll back the safety net for at-risk populations, particularly women and girls of any background. We feel that there are significant improvements that can be made, and we ask that you oppose this as written in its entirety until we can get the author and sponsors to change it to a meaningful, implementable bill. Thank you.
Thank you for your comment. Julio De Leon would like to make a comment. 1 second, please. Go
Good
ahead.
morning. Can you hear me?
Yes, sir. Go ahead.
Very good. Good morning, committee and board. My name is Julio De Leon. I'm a lieutenant with the Riverside Sheriff's Office. I am the department's legislative representative, and we've been involved in this type of legislation for the last 3 years. This is the third iteration of a bill of this sort, and we've opposed it every single year. And this year, we are concerned of the language and the dangerousness and the unintended consequences that this bill could provide. We did an analysis in our agency. If you don't know, Riverside County is the fourth most populous county in the state, and we have the fourth largest police agency in the state as well. We cover 17 contract cities throughout our county, and we service approximately 2 million people throughout our county. And in those 2 years, between May of 2022 and May of 2024, we have had a total of 678 domestic violence incidents where either strangulation or suffocation was a factor. Now, that doesn't include the total domestic violence incidents that we've responded to. That just includes the ones that we've identified as either involving a form of strangulation or suffocation. And that is very significant, 678 in 2 years. And the data is pretty clear on this. The red flags in domestic violence are clear, as Casey spoke about. The data indicates that women who are strangled are 750% more likely to be killed by the same partner later. Now, with the current language, if we aren't allowing we eliminate the mandatory reporting of strangulation or suffocation, then this could potentially lead to more women dying of domestic violence in our state. And in the committee hearing, in the legislative committee hearing last week, I believe, the proponents came on and said, well, Kentucky, the argument was made that Kentucky is now the most dangerous for women because they did eliminate mandatory reporting in that state. And the proponents came up and said, well, there were other factors, or there could have been other factors, not necessarily only the mandatory reporting that was taken away, but they were unable to provide any other factor. So that's just a way of I'm also an attorney, that's just a way of our defense attorneys raising some reasonable doubt without any proof of any evidence to support that claim. So we're just afraid that California may lead to, if this bill passes as is, then we may lead to statistics similar to Kentucky, and it would lead to dangerous and potentially deadly encounters involving domestic violence. So thank you once again for allowing me to speak.
Thank you for your comment. Board President Trujillo, there are no other public requests for comments on the WebEx. Do we have any public requests for comments there in the hearing room?
We do not have any other requests for comments here.
Thank you. Would you like me to close this window?
Yes. Thank you. Okay, we have a first and a second on the motion. Prior to a vote, Board Member Patricia Nguyen.
Thank you very much. So the public comment kind of led me to even a stronger opposed position, but Lori and Melissa, I do want to be very mindful. If this takes us out of the conversation completely, I would like us to be in the conversation, but I can't imagine an amendment that would address these concerns. So I just thought I would put it out to you. You had suggested maybe we do an amended, so.
I would, if there's certain changes that the board feels they would like to see that could move it to a place, then I would say to do an opposed unless amended. I think at the end of the day, it's where the board feels they stand on this bill in its entirety. When you do an opposed, they can still reach out to us. There's nothing precluding that. The amended essentially means that if we were to do X, Y, Z, it would remove our opposition. So if there are those provisions, then that would be appropriate. If there isn't, then so whatever the board feels is correct.
Just to provide some additional clarification, if you had specific areas that you would want amends, that gives me specific areas to focus on in those conversations, right? But if there is not any specific areas that you want to focus on, that you want the authors to know that these are the areas that you want them to work on, maybe in next year's reiteration of the bill or at the end of this session to try to get this to a bill that is more palatable for our board, then saying just a direct oppose is completely appropriate, and I can represent every item of why we are opposed and put that out there. So it just gives me direction, but I don't necessarily need that direction. I just wanted to let you guys know that if you guys had specific amendments, I could focus on those specifically. But if not, I'm totally okay with supporting an opposed position if the board votes that way.
Thank you, Lori.
Board Member David Lawler.
Thank you. I do appreciate the clarity, the precision, the persuasion of the public speakers, which made me write down the question ahead of time. What amendments would get you to support it at this point? And so without knowing what those are, if none exist, it sounds like instead of trying to figure that out to help them, just oppose it outright.
I think one of the things that we heard in public comment, and one that I had shared as well, is really having them look at the current process that's in place for the sexual assault victims. that has the ability that the victim chooses whether it goes to law enforcement for immediate intervention or whether or not it is held by law enforcement for future potential choice. It gives the victim that ability to say, I want this documented. I'm here to seek services, but I don't want them to know that I am here. So please do not have law enforcement show up at my home, or please do not have law enforcement show up wherever this might be, because they don't want to aggravate the assaulter in any other manner, because maybe they could not escape or get to a place of safety immediately. And so the current non-incident reporting that is done within the sexual assault community allows for evidence collection and proper storage that maintains chain of command. It allows for reporting so that the community, the state, the people that are choosing to move to those locations know what the crime statistics are. And it allows for that, the main one is allows for that victim to feel like they have the power of how they want their care to be done. And so that current process that is done within the sexual assault community, nursing and medical community, sorry, kind of is that balance. You know, they have 18 months to come back. And again, I'm talking 10 years ago. I've been out of that community for 10 years. So 10 years ago, when I was a part of that, we had 18 months where they could come back and say, you know, I do want to pursue charges, and then that can be reopened and move forward. So it does allow for, I believe, a lot of those fears to be addressed, and to give the victim of this occurrence, this assault, whatever occurs, the kind of onus of themselves, where this can go to law enforcement or this can't. And so I think that there is an opportunity out there where we can address that does allow for what everybody wants. I don't understand the opposition for moving with that. I did meet with the sponsors. We had a robust discussion. I even brought up the strangulation aspect, because on initial review of strangulation, when a person comes in, they may just be clearing their throat. They may just talk with like kind of a raspy voice, and you might think it's an illness. And then they go home, and the esophageal and tracheal swelling continues, and they die silently. So strangulation is definitely a issue that, you know, was brought up in conversations as well, and was brought up in public comment again today, because that doesn't present as an immediate life-threatening incident, but absolutely can be. And so we do want people to seek support. We do want them to seek medical care. And I know that what we're hearing from the sponsors and what we're hearing from people involved in this, that if it is a mandate of reporters, some people do not seek care. And that's why they're bringing this forward, is because they want the people to seek care that wouldn't seek care if this was going to be reported out to the police. So I understand why this law needs to be looked at, why it does need to be addressed. But I do think there is a current process out there that it would be nice for people to take a look at, to see how that has been working for the last 15 years. And that it does give the victim the ability for self-choice. But it also allows for statistics. It also allows for process. It also allows for a chain of command. It allows for a lot of these assistances.
Thank you, Lori. Any other questions or comments from board members?
I have a
Vicky's
comment.
hand is raised.
Vicky Granowitz?
I guess the thing is, this is moving forward without any studies that define what we're talking about, because there are differences between stranger sexual assaults or friend sexual assaults, child sexual, well, the child stuff is different, but where there's familia, where there is domestic violence. And sometimes people, if they can say, I have no choice, they're more likely to report, because it's out of their hands. And so they can say, this is just what the law is. And so there's no research that I'm seeing that shows me that the supporters know what they're talking about, other than that they think this will work. And I mean, I don't mean to offend anybody, but I'm also persuaded by the woman from the rural community. There will be no money put forward to implement the warm handoff, to increase resources. So you will have a process that can't even be implemented in significant areas of our state. And those unintended consequences are going to be really problematic. So I just think this whole thing seems ill-advised and rife with unintended consequences. And so the more I listen, the more I think about it, the more I just think it's a bad idea.
Board Member Neelu Patel.
I have a question for Marissa. I don't know if you know the answer at all, or if it's come up. Is there any legal implication if this bill were to pass and a provider were to report it anyway? Do you know if there's,
Meaning if they were to report it against the patient's wishes,
Right.
essentially, I am not sure. I'm not sure what
concern
that
of mine?
would look like.
I'm also not sure, but when it's mandatory reporting and it's spelled out in law that it's mandatory, you have some, as a provider, you have some shielding. The concern that just pops into mind, and again, I haven't really analyzed this, but is the sharing of personal medical information with somebody when you don't have an obligation or their authorization to provide it. So it seems risky, but again, I can't say for sure.
Marissa, if I'm right, wasn't there some language written in that protects the healthcare providers on the reporting? I think that was added last year.
Correct. So in the bill, if this bill were to pass and that mandate were to go away, pull it up real quick.
I think it was more around non-reporting, right? That they were protected for non-reporting, not protected for reporting.
Correct. But let me
I'm not
verify
sure.
this because that is.
This is Board Member Cormack. Your report on page 16 does have a paragraph that addresses this if you're looking for it.
Thank you.
It says in subdivision, I don't know if this is what you had in mind, but a health practitioner shall not be civilly or criminally liable for any report made or not made pursuant to this section, or for any other acts taken or not taken in relation thereto or resulting therefrom in good faith compliance with this section and other applicable state and federal laws. So that is to say that if this were to pass, if a provider made a report that was mandated under this, they wouldn't be held liable. If they didn't make a report that was not required, they wouldn't be held liable. I'm not sure that answers the question of whether currently, I think you were asking about currently, if somebody makes a report without the consent of the patient when they're not required to, whether they would face liability.
Currently, we are required to make a report and it's not based on consent. I think that was kind of the overarching issue that the bill sponsor brought forward is, as a healthcare professional, when a person presents in front of you and you are made aware of this, you are mandated by law to report, and the patient does not have a say in that.
Any other questions or comments from board members? All right, we have a first and a second on the floor. BRN moderator, please. No, we need to vote. All right. Dolores Trujillo votes yes. Board member Allison Cormack.
Cormack, yes.
Board member Jovita Dominguez.
Dominguez, yes.
Board member Patricia Nguyen.
Win, yes.
Board member Neelu Patel.
Patel, yes.
Board Member David Lawler,
Lawler, yes.
and Board Member Vicky Granowitz.
Granowitz, yes.
Thank you.
Okay, so the next bill is Senate Bill 607 by Senator Portantino. Current law requires a prescriber for their minor patients to discuss all of the following with either the minor's parent or guardian, or another adult authorized to consent to the minor's medical treatment before they directly dispense or issue the first prescription in a single course of treatment for a controlled substance that contains an opioid. They have to discuss the risks of addiction and overdose associated with the use of opioids, the increased risk of addiction to an opioid for an individual who is suffering from both mental and substance abuse disorders, the danger of taking an opioid with I'm going to mess up, benzodiazepine, alcohol, or another central nervous system depressant. There are exemptions to these requirements in law under the following circumstances. If the minor's treatment includes emergency services and care, if the minor's treatment is associated with or incident to an emergency surgery, and if in the prescriber's professional judgment, doing so would be detrimental to the minor's health or safety, or in violation of the minor's legal rights regarding confidentiality. There's also another exemption in law that I failed to include in analysis because it was in a previous version and I caught it when I was doing notes, is there's an existing exemption in the law for diagnosis of chronic intractable pain. This bill does propose to strike that exemption, but it would add an exemption for those receiving hospice care. But in general, the main provision of the bill is that it will expand the requirement for prescribers to discuss the risks and dangers of opioids and opioid addictions from only just with their minor patients to all patients they work with. Happy to answer any questions.
Board Member Allison Cormack.
Thank you, Chair Trujillo. Ms. Clark, how long has the requirement for describing these dangers to minors been in place?
That is a good question. Let me see if I can find that right now.
And the reason I'm curious would be that if this has been effective, then certainly of more interest. But if this has either been in place for some period of time or has not been found to change things, usually I'm a big fan of education.
Looks like it was established in 2018.
Okay. Thank you for that. And there's no description in here about using words that general folks would understand, like a word that's different than benzodiazepine or
No.
we're not, the bill doesn't ask to explain it in ways that your average person would understand.
It doesn't. I don't know if it's assumed that because the bill is speaking to the prescriber, it's assumed that when the prescriber communicates, there is that translation. But to your point, there's nothing that specifically requires it. Correct.
Okay, well, I'll be interested to hear what my colleagues have to say on this.
Any other questions or comments from board members?
I was surprised we're at this point in the session and there is no support or opposition on file.
So there has, since the analysis was posted, there has been both. It was recent. This committee hadn't come up for, or this bill hadn't come up for
Okay.
committee yet. So that's sometimes
Okay.
the tricky part with the delay. So just recently, when the analysis was posted, I can update the registered support and opposition. Support is the California Association of Highway Patrolmen, the Chrysalis Center, and the Medical Board of California. And then the registered opposition is the California Medical Association and the California Orthopedic Association.
Yeah, I am aware of what's going on with opioid addiction in our country, and it is tragic. And I also see that the need for opioids when people are, experiencing enormous pain. And I guess I just don't really know enough to know whether if you say, I want you to take this pain medication, but people get addicted, I wonder if it's, kind of at cross purposes. So like Allison, I'm curious to know what people think about it because I don't feel like I know enough to make a really informed decision on a bill like this.
Board Member Neelu Patel.
As an anesthetist and giving opioids on a regular basis for procedures, I can say that there is an actual need, of course, and we always educate our patients who are recovering and don't really take or don't want opioids. It's what we have. There are quite a bit of studies to indicate that we can do non-opioid interventions to help with pain, especially for patients undergoing procedures. And there are CRNAs actually really involved in doing non-opioid types of anesthesia, which is very effective. But in this particular instance, taking home medications, that's not really, there aren't very many options. So I think educating the public and expanding upon the education is a really good idea. So I support.
Yeah, I personally, as a nurse, believe this is a good idea. Board Member Vicki Granowitz.
I think this is a good idea, and maybe I'm missing it, but there's a level at which minors can't understand this discussion. And so there's no discussion about that sort of defines sort of an age range or an assessment of the cognitive ability of a minor to understand this information. And so am I missing something?
No, you are
I
not,
don't think,
Vicki.
yeah, I don't think you're missing anything directly from the law. I would like to share just a couple of little different things. Consent law in California, minors can consent. I believe it's, and correct me if I'm wrong with the nurses on the panel. It's been a while since I've had to quote this kind of data. I believe it's 12 years old and above, we can do a minor consent. And at 12 years old, they can assent for sexual transmitted infections. They can do mental health treatment, pregnancy, and not have a parent involved, so, or a guardian. And so at 12 years old, I believe that is what the law is that has deemed here in California that services and education and stuff like that can be provided directly to that minor. On beyond that, when you're looking at nursing, the practice of nursing and medicine, when you're practicing nursing, our role is to provide care at the developmental age of that person, not the chronological age of that person. And that includes adults that may have severe mental disabilities as well. So we always, in our care and our education, provide that at the appropriate developmental level. And just an example that doesn't necessarily live around narcotic use, but we have 3-year-olds that are diagnosed with leukemia, and we talk to them about their leukemia treatments, their chemotherapy that they're going to be undergoing, the pain medication, and the treatments that we're going to be providing to them. And they have unfortunately, they end up with a very good understanding of the treatments that they're going through, even at that young of an age, and even understand death and dying when faced with that. So within the medical community, that is our ask. And that was always what we are to do, is to provide care at the developmental level of the person that we are caring for, not the chronological age.
Just to clarify that the current law already requires the notification to the minor or the minor's guardian or whoever consents to their care. This law is then expanding the notification to also be provided now under law to adult patients. So it's taking it from just minors where it's required now to now adults.
Thank you, Marissa. Board Member Allison Cormack.
So I just quickly looked up the average reading level, and it's grade 8 across the nation. And I didn't want to spend any more time on this, but California. So I guess before we go adding amendments to this, maybe perhaps Executive Officer Melby or Ms. Clark can share with us, in the past, has the legislature ever specified, or is it helpful in the nursing profession to have this is the level at which this important information should be communicated?
Not specifically in laws that we see like this.
Okay.
There are various insurance billing laws. There's,
Right.
various other entities and accreditors and stuff that come in that have specific requirements, but not specifically in this law that I've seen.
It seems to me that when one is in pain and about to receive a pain medication, that, simpler language is better. So I'm wondering if this is something that, the board members and the board staff are interested in, to suggest that these communications be in a level that is understandable, to most adults, or the average adult. I'm searching for what the right description would be, because if this is anything like what you get when you pick up the meds, I have reading glasses, but you get a magnifying glass, and there's a lot of, legalese. It's actually not the information that you need, that type thing. So I'm just thinking that for this to be effective, it needs to be communicated. And that would probably be helpful for the practitioners who are busy at the end of, a visit or a surgery, trying to share this important information. So interested if, when we get to motion, which will no doubt be shortly, if we, consider suggesting to the author that they look at this topic in order for this to be an effective intervention.
Board Member David Lawler.
Considering the bill is just expanding the requirement to educate adults on the dangers and addiction properties of opioids, I can't imagine a healthcare provider using only discipline-specific language with a patient without speaking to them in language that they would understand. And I base that only anecdotally on all the times I've had to visit doctors and nurses with my parents, which is about 2 or 3 times a month. That being said, I agree if that's a concern, because we don't believe healthcare providers do that normally, then of course we should add that kind of language to this. But I guess my comment is I'm stunned and surprised, because you would think, when does this not happen anyway? So it's sort of a no-brainer in a sense to me personally. I'm looking at this going, well, of course they do that. We're talking opioids. But anyway, I just had to add that comment. I can't imagine any doctor talking to me or nurse, and if they say something and I cross my eyes, then not explaining to me in my own words.
Thank you, David. Any other questions or comments from board members? No? Seeing that there's go ahead, Reza.
I'm just giving a chance for board members, but this is Reza. Just a couple thoughts, kind of playing off Allison's comment. One is just one way that, and this is not likely the only way, but in law sometimes, especially kind of more modern, trend is to require what's referred to as plain language in communicating legal requirements or medical information or whatever. So that's one way, again, probably not the only way to maybe describe what you have in mind. But the other kind of flip side, the concern that, again, just somewhat speaking out loud, is if you impose a requirement that the information be conveyed in a certain way, is that kind of creating some, grounds for complaint or liability, that patients can say, well, I didn't understand the information. They didn't provide it to me in a way that I could understand. And of course, that is the goal, that the provider give the information to the patient in a way they can understand. But is that kind of opening the floodgate to another type of complaint? And part of the other thing that I think comes to my mind is, as a patient, if you're given information, I think a lot of patients are given a whole lot of information that they voluntarily allow to kind of go in one ear and out the other. But then there are, patients who are actively, as as we would hope they would be, actively trying to listen and understand. If they don't understand, I think there's some onus to ask the questions and seek that clarification. So it can go both ways, whether, imposing a mandate that the language be clear and understandable, or on the other hand, kind of putting the responsibility on the patient to ask if they're not sure, really.
Board Member Neela Patel.
Just to add to my perspective on this, when opioids are prescribed for postoperative pain relief, they're just prescribed. Oftentimes it's not discussed with the patient. So I think this would really enhance that, like it says, expand it to adults to really indicate that this is a drug that can be potentially abused and if it were to continue. So I think, again, just in support of the education aspect of this.
Board Member Allison Cormack.
That's very helpful. And I wonder, Ms. Clark, if, do we have any indication what the pharmacy board is thinking about this? Because I can imagine this is how people end up with, do they think it's a good idea for the providers to be discussing this? Do they think it'd be more effective to have a different kind of warning that comes with it? Should they be aligned? I guess I'm feeling like this is a little bit standalone. So I'd be interested if you know anything about what the pharmacy board thinks about this.
I don't know of them going on record yet. The only one
Okay.
I've seen formally on record that I'm able to verify would be the medical board, and they were in support of it. I'm not sure if other boards have weighed in on it.
Okay, thank you. Is the chair ready for motions?
Yes.
All right, then I will move that we support Senate Bill 607.
I'll second.
Thank you. BRN moderator, can you please take us out to public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comment. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in the hearing room?
There are no requests for public comment here.
Thank you. Would you like me to close this window?
Yes, thank you. All right, at this time, we will vote. Dolores Trujillo votes yes. Board Member Allison Cormack.
Cormack, yes.
Board Member Jovita Dominguez.
Dominguez, yes.
Board Member Patricia Nguyen.
Win, yes.
Board Member Neela Patel.
Patel, yes.
Board Member David Lawler.
Lawler, yes.
And Board Member Becky Granowitz.
Granowitz, yes.
Thank you.
So the next bill is Senate Bill 639 by Senator Limon. This is a 2-year bill that recently underwent a gut and amend, meaning the language was essentially removed and replaced. So I do want to note that the bill analysis included in your meeting materials does not reflect the current language because the changes happened recently. However, I will share the new provisions with you all verbally twice. So currently the bill would amend specific healthcare providers' continuing education requirements to require general internists, family physicians, physician assistants, and nurse practitioners that provide primary care to a patient population, of which over 25% are 65 years of age or older, to complete at least 20% of all mandatory continuing education hours in a course in the field of gerontology, the special care needs of patients with dementia, or the care of older adults. So just to repeat, solely focusing on the BRN portion, the bill would require all nurse practitioners who provide primary care to a patient population, of which over 25% are 65 years of age or older, to complete at least 20% of all mandatory continuing education hours in a course in the field of gerontology, the special care needs of patients with dementia, or the care of older adults. And I did want to note that in discussions with the bill sponsors, they reached out and there were some technical concerns that we raised just purely from an implementation standpoint. First being that nurse practitioners do not have a separate continuing education requirement. There's just that 30 hours that is attached to an RN's license. So there's a concern that the language could potentially not be implementable since it appears to apply that gerontology course requirement to an NP's CE hours, which again, there isn't a separate one. We also shared that the board does not currently track the percentage of each patient population that our licensees work with or the specific content areas they do their CEs in. So we wouldn't necessarily have the ability to audit for compliance, but compliance could be verified elsewhere through the employer, et cetera. And also shared that there are some other APRNs that work with this general patient population as well. So just want to communicate everything we communicated to them. Happy to answer any questions.
Thank you, Marissa. Board Member Allison Cormack.
Thank you, Chair Trujillo. Ms. Clerk or Ms. Melby, do we currently have any laws for nurses that specify the CE courses they must take? I remember when we went through this last time, there were recommendation. If
All
this
of ours
passes,
are recommendations.
okay, so this would be the very first requirement about the type of content a nurse is required to take for continuing education.
We have
It
one
would-
for implicit bias.
So implicit bias is required for everybody.
Okay.
And so the one requirement that we have for implicit bias is that with any continuing education that you take that is not like research-based, essentially, you know, just a quick down and dirty, that the provider must include implicit bias. So it is not a licensee-specific requirement. It
understand.
is a provider-specific requirement. There
Okay.
is another implicit bias requirement out there that says you must take 1 hour of implicit bias on your very first renewal of your license. And that was specifically targeted towards people that have received education not within California schools. Our California board approved programs are having an 1 hour implicit bias requirement as their graduation requirement. And so that was added in. But there is not this level where it is a specific population of nurses that this is affected, or a specific specialty of nurses that is affected. There are that implicit bias provision that is provider specific for your continuing education provider. And then everybody has the 1 hour requirement on their first license renewal.
Okay.
But
I can.
But really, I mean, the way that the bill is written right now, even if it's something that you guys want to support, it is not implementable as written. So we do need from the board a support with amends or a smart if amend, and then we will have to request amendments because I can't implement this bill the way that it's written today.
Just one quick thing. I think this is also distinguishable from this, but you asked about other provisions. I think there's one other provision about NPs who furnish Schedule II controlled substances and that they have to take a CE course related to that. But again, very kind of narrow, not quite as broad as this.
And again, that is a specific additional kind of certification. So I'll explain the furnishing process with California is we have 2 license types right now that are eligible to elect to become furnishers, which is loosely described as prescribers. And so that would be the nurse practitioner or the nurse midwife. So that furnishing license, you can have that license, you can have your nurse practitioner license or your nurse midwife license, and you can operate in your realm. And thank you for pointing that out, Reza. With Schedule II, there are renewal requirements that the CEUs that a nurse midwife completes 2 hours of CEU specific to Schedule II, prescribing opioid addiction, et cetera. Nurse practitioners complete 3 hours in that same content, and then they're able to renew their Schedule II kind of additional certification to their furnishing license that is also an additional certification to their nurse practitioner or nurse midwife license. So again, nothing that is as specific as this.
Okay, so I just have some general thoughts, right? It's certainly plausible that there are practitioners, in the state who did not learn of the research that was, when they went through their initial training, and perhaps there's more information available now that would help them to provide better care to our older population. So that's certainly plausible. I will say I just have, having served on boards and councils before, I have some fear that this would open the door to, a lot of things that would add up to more than 100% over time, because there are many, many important populations in the state. And, we would all hopefully want to believe that, that everyone was up to speed on everything, which I think would be quite difficult. I think the other thing I wonder about is if this is, again, the question I ask so often, what is the problem we're trying to solve? And if there is, evidence or, that whether anecdotal or database that nurse practitioners are, not up to speed on the latest developments in gerontology or dementia, I think that, I'd certainly be interested in understanding that. Again, at a reflexive basis, does it make sense that we would want people who treat this population to take these courses? Yes. But I certainly, and we've seen this in the past in other, not these related areas, the desire for a particular segment of the population to carve out their part means that at the end of the day, I worry about it adding up. So those are the thoughts that I have. I'll say 20% doesn't seem like, a huge number, but I can imagine if someone was a midwife, a nurse, a nurse midwife, I can see how that would, it would be really hard to track at the end of the day. Did I complete everything? So I'll be interested in hearing from my colleagues on this. I certainly understand that, our population is aging, and there's probably information available that we would want our NPs to have. I'm going to be interested to hear what others have to say.
I think just to reiterate real quick, on the implementation of this, NPs do not have a CEU requirement. The RN does. So right now, 20% of nothing is nothing. And so again, I cannot implement this the way that it is currently written. And so that is of concern. And typically, specific CEU requirements are done through an accrediting board or the employer. It is not typically done through our board. So if you're working in a hospital setting in a labor and delivery unit, and part of your annual performance review is that you go to a skills fair and you get recompetency validated on many of the items that you perform on an annual basis. That also does continuing education specific to that employer and that role that you serve at that employer. Additionally, when you have a person that operates under policies and procedures at the hospitals or clinics and standardized procedures, those policies and procedures outline what needs to be done to maintain competency. And that could, based on, again, employer and insurance agencies and accrediting agencies, et cetera, that are utilized by the healthcare facility that they're employed at, may have specific continuing education requirements. So this type of specificity doesn't typically live under a regulatory body, but more an employer accrediting agency or insurance company.
Board Member Nilu Patel.
Actually, Lori just highlighted everything that I was about to say in terms of the fact that it is built in really into the system of those that are providing care, and to mandate that a provider who sees 1 in 5 patients be required to take additional courses. And 20 hours is quite a bit of time for this particular patient population, again, where does it end? Just like Board Member Cormack stated. So well, although I think it's very important, I think it's built into the system that education is, there, standardized procedures are there, and then a referral system exists for those that are specialists in this type of area. So
Any other questions or comments from board members? At this time, I would like to make a motion. I would like to watch this bill. At this point, I don't know that we could support because there are too many questions of how this would be implemented. But I am curious to see what happens with this bill. So I would like to make a motion to watch this bill.
Marissa, I have one question. Oh, I was trying to get it before the second. I need to reiterate again, I cannot implement this bill as written.
Exactly.
So
Yes.
as we watch, if it gets passed, I have a bill that I can't implement.
This is Reza. Can I
Please.
I just wanted some clarification on the implementation problem. It's amending our general CE statute that applies to all RNs, but it does specifically say that NPs in fulfilling that requirement have to fulfill this percentage. And as far as like compliance and audit ability, that's certainly lacking, given that we don't have these numbers or the means to verify, the percentage of one's patient population. I think it could conceivably be implemented with those, and hopefully the author would understand that we would essentially be having no ability other than to take the licensee's word for it. But beyond that, I just want to make sure I understand and the board understands what's the what's the actual amendment that would need to be made.
I would need language that speaks to the nurse practitioner's RN license CEU requirement. I need it to say that 20% of the nurse practitioner's RN license CEU requirement, because then I can tie it back to the RN license CEU requirement, and they can give us 6 hours because that's what 20% of 30 is. But if it's just tied back to an NP CEU requirement, NPs do not have a CEU requirement specific to their license. It is specific to the RN license, which is what this provision is about. And so for implementation, clarification, all of that, and if we ever had to take this, if we received a complaint, because this is a shall, if we received a complaint that said this person did not do this, and then we had to do an enforcement and complaint and investigation, this would not stand essentially with this clarification to be able for us to take any action on it, whether it even be like a cite and fine. We would see this challenged. And I don't understand what our level of defensibility would be at that point. Again, because this is a shall, it's not a may or could or anything like that. So then I have to be able to do any kind of action if that is not completed. And so because there is not a specific CE requirement tied to NPs, we could see that argued. Because I have no way to track or require this to be turned in because I don't know employment data, and because I have no ability to take action if this is not done. So, and if it's tied to license, CEUs are all tied to licensure renewal. If for some reason this wasn't done, then they potentially could not renew their license. And so that would be an impact as well. So I would need this language addressed to not have those unintended consequences and to be able to that if the board was to take a support position. If the board was to take an opposed position and put this back into the hands of the employers where it lives today, then obviously I would not need to be able to do this. But which with a watch position, this bill stays as is without any board position that we can give to an author. And if this passes, because it's not a bad bill, I just will have great difficulty implementing this and doing anything if this is not done, as this is a shall.
So a couple of things. There's two, I think, issues that have kind of generally been brought up with this bill. One is the lack of a real meaningful ability to enforce non-compliance with it. And the other is the issue, the confusion over, NPs not having their own specific continuing education statute or regulation, and that relating all back directly to the RN CE requirement. So just a couple quick things on those 2 points, then I'll leave it there. On the enforcement piece, again, as was said, you don't have this data, you don't collect it, so you couldn't really enforce whether an NP is validly certifying whether or not they have 25% or more of their patients over 65 years of age. That piece of it you couldn't really do much with. You do have the ability to enforce if a NP does make that certification, then they have to comply with the second part that requires them to complete 20% of their CEs in this particular area. So there's some room for enforcement. It might not be, I think the enforcement where you do have the ability to do some enforcement is kind of missing the bigger area of you don't know whether they are certifying correctly or not to trigger that requirement in the first place. That's on the enforcement side. On the other issue of can this practically be implemented based on it not referring to a specific NP CE requirement, I think it may just be a difference in how we're reading it, but I think I could read it in a way that makes sense. It requires NPs to complete 20% of their 30 units that are required as RNs to be in this area if that trigger is met, that 25% or more of their patients are 65 or older. So personally, I'm a little less concerned about the first issue.
If they don't do the 6 CEUs as 20% of that, then we don't renew their NP license. Is that accurate? We remove their
If they
license.
certify that they've done, if they certify 25% of their patients are 65 or older, and if they don't complete 6 or more CEs in a renewal cycle in that particular content area, then I would think that the ramification would be non-renewal. But that's an area that would be helpful to be spelled out in here, that the outcome is non-renewal.
Because again, our requirement is 30 for renewal of RN. So that's where it becomes very confusing. And then how do I roll that out with staff? So those are the concerns, especially when we only audit RN CEU renewals.
So I think the last thing I'll say is the board could take a more strong position based on those issues and either support if amended or oppose unless amended, or, as I think is the current motion, watch. And if the board were to take a watch, I'm not sure that rules out any continuing. I mean, I don't think it rules out continuing dialogue with the author about these areas of uncertainty and
That's helpful. Thank you.
Board Member Leela Patel.
So I just want to say that I'm largely in support of the other items on this bill. I think it's a great bill. I wanted to consult Reza regarding, could we say something to the notion of suggesting this many hours in this particular area rather than mandating it as an amendment?
So Marissa, Can you clarify, this was put forth by an organization that is looking at accrediting? What was the reason behind this bill again?
So the original version of this is a 2-year bill, so it started last year and then it made it pretty far in the process, but not quite across the finish line. And the sponsor was California Alzheimer's Association. And in just kind of discussions with them, I think their main focus was trying to increase early identification and diagnosis around Alzheimer's and dementia. And so the previous version of the bill focused on these existing centers that are funded through various state agencies, one through CDPH, one through DHCS, and making sure there's more coordination and there's more robust information. In the hopes, I think, that healthcare providers go to those centers and get the information. This now, I think, has changed a little bit, where instead of having that hub where the providers go to, it's instead inserting the education requirements into the providers' codes. So I believe that it's still the same intent of increasing awareness and trying to increase early diagnosis. It's just switching how that information is delivered, if that helps.
It does. Thank you.
And I think if I understood correctly, you were asking if it's an option to suggest that the author revise the mandatoriness of this bill to a suggestion. And if I understood that correctly,
That's correct, yes.
you can suggest that. And I think it's not unheard of in the law that there be something like a suggestion rather than a, true legal requirement. My personal opinion on some of that stuff is that it at the end of the day, if it's not a requirement, most people kind of overlook or don't even know about it. So it's one of those things that if you want to kind of send a message, that's why those things are often done, to kind of just convey, a message, a policy position, without coming out and imposing some requirement.
Right, and then I understand that is sort of moot, but I think if it's written in this law that there's a strong suggestion to have some education in this particular area, I think that goes a long way rather than mandating it. And so I would like to see this bill, I would be in support of this bill if we amend it to indicate that legal obligation of mandating hours for this particular specialty be removed.
At this time, I would like to withdraw my original motion from the floor. And in light of the discussions that have taken place after the motion, Board Member Neela Patel.
Sure, I'll make a motion to support this bill. No, sorry, I make a motion to amend the bill by removing the language that education is required. And that's it.
So if it helps clarify, just in informing the position, whichever way you want to go, a support if amended means if the amendments aren't taken, then we're deferring to a neutral. An oppose unless amended means if the amendments aren't taken, then we're deferring to an oppose, depending on how strongly you feel. I just want to clarify that.
And so Nilu, was your motion a support with amends or just amends?
My motion is to oppose at this moment. I think that would be the best.
Oppose unless amended. Okay.
Thank you.
I will second Neela's motion. Board Member Allison Cormack.
I will be supporting this motion, not based on the specific implementation things that were discussed, because while they're important, I believe that they could be managed through, but because I am persuaded by the description of the fact that currently continuing education requirements are done through an employer and or accreditation. And I believe that's where the decision about the current continuing education that a nurse should reside, not with the legislature and therefore us, because we will inevitably be behind the curve and less knowledgeable. So again, based on the fundamental belief that The people closest to the work should be making the decisions about further education. I will be supporting the motion.
I just want to make sure that I understand the motion. It's to oppose unless amended, and the amendment suggested is to remove the requirement that it be, just remove the mandatory education. So what would be left if that amendment were accepted? And I'm just confirming if this is what you're intending. It would be left with the requirement that they certify. Because currently it requires, one, that they certify if their patient population is at least 25% 65 or older. And two, if they certify that that's the case, that they complete a percentage of their CEs in that content area. So are you?
Thank you for
said to remove
clarifying
the
that.
Education, but
The first part needs to
Oh.
also, referring to both. Yes, the first part also needs to be, because I think it would be very difficult for us to, just follow and track that.
So if it were, so are you suggesting on the one hand that it be revised to suggest that that they do CEs in this area? Or because what I'm ultimately kind of getting at is if you take those pieces out, it's left with nothing, really. In which case you might as well oppose it unless you're suggesting that it remain but be altered such that it's suggesting that. In which case it's kind of, again, just a policy, like a message that the legislature would be delivering that would, we couldn't do anything about it.
We had some language that we worked with the authors on, and I'll read that to you guys. It says, for the purpose of fulfilling the requirements of this section, all advanced practice registered nurses who provide primary care to a patient population of which over 25% are 65 years or older shall complete at least 9 continuing education hours focused on the additional advanced practice educational preparation and skills consistent with the field of gerontology, the special care needs of patients with dementia, and the care of older patients. Compliance with this provision shall be verified by the healthcare facility where the advanced practice registered nurse provides primary care services to a patient population of 65 years of age or older. When this was first brought to us and we met with them on implementation, we shared with them that in the current language that they were sharing with us, this was not able to be implemented. And so Marissa and I worked together to share with them some suggested language that would address the APRN, that would address the specificity of additional hours above that of what is required for their RN license. So the RN license was left alone at 30 and we didn't have to worry about that. So that would not affect their renewal process. And that, so that would remove an unintended consequence. And they chose a number, and that number was at least 9 continuing education hours focused on the additional advanced practice educational preparation, because again, our CEUs for RNs, which is what we have the law around, our regulatory carry out of that says that continuing education hours need to be above the pre-licensure nursing education, which is not what you would see as an advanced practice RN. Advanced practice RNs need to have advanced practice RN specific education to be able to be effective at a provider level. And so we added the language that said with a continuing education hours focused on the additional advanced practice educational preparation and skills consistent with the field of gerontology. And then we addressed the compliance because we have no way of auditing this. We have no way of tracking this. And we would truly not want to be involved in doing any kind of disciplinary action if this was not followed through, is where we then put in that the compliance with this provision shall be verified by healthcare facilities where the advanced practice RN provides the primary care services to a patient population of 65 years or age or older. So it puts it back where it lived previously and does not put any problem on licensure renewal. So that is the language that we had shared with the authors prior to it coming to our board to try to address the various provisions. Again, knowing that our CEUs are tied to the RN license, and even our regs, when we're addressing CEUs, does not require them to be at the level that they're asking for them to be in this provision. So when I met with Marissa and we're talking about this, we were looking at other processes our boards do. And we have the ability for nurse midwives and nurse practitioners to perform aspiration abortions with additional education. And that education is specified as to what that is, and that is not monitored by us, right? That is done at the institution that they are providing that service at. And so again, it removes that from our board's oversight, but allows for that additional kind of more specific scope of practice to happen under that specific provision. And so we tried to mirror that similarly with the language here that addresses the need for the advanced practice. Continuing education, it addresses that it would typically be done in a healthcare facility as well.
Board Member Allison Cormack.
Okay, so that's additional information, which raises more questions. So thank you, EO Melby, for sharing that background. I will just say, and I don't know where we're going to end up. One reason watch might make sense is we all prepared for something that is completely irrelevant, and now we're basing it on 3 sentences. So, you know, reasonable if we just say like watch because we're not actually sure what's in here yet. So how many extra hours do APRNs do above the 30 hours for the RNs?
None. 0.
So-
It is not in our provision to require
So-
that.
So what was so you referenced that you had suggested to the author 9 hours above the 30?
So a physician is required to have 45 hours of continuing education at the provider level to renew their license.
Okay.
In our AB 890 implementation, there was the Office of OPES, Professional Education Services, did a review on nurse practitioner specific, and they had suggested that we increase nurse practitioners by 15 CEUs as a specific requirement for NPs to then equal the 45. So if we were to look at what physicians do, what OPES was suggesting we do, then nurse practitioners would have 45 hours. That would be equal. And so 20% of 45 came to 9 hours. And so when meeting with the authors, that's kind of what we had discussed. So then the suggestion to keep it equal to what a physician would do would be to require the NP to do additional 9 hours above their 30 CEUs if they meet these specifications. And it does not affect their renewal of their license. It also pulls that CEU from being a regular CEU that is just above the pre-licensure level, which is kind of still basic RN and not advanced practice, giving it a specific advanced practice focus, which again more aligns with what they're asking for identification and diagnoses, where pre-licensure, post-licensure nursing education, continuing education does not deal with specifically with diagnosing, et cetera. That's advanced practice. And so, and then it addressed the compliance provision, which would be back at their employers and not with us.
So I understand that math and the reasoning. It all presumes that the 25% is a magic or accurate number, that 25% of someone's practice being a specific population. Like, is there, what do we know anything at all about that number? I mean, like, you know, member of the public, I'd be like majority, like more than 50%. So I'm actually less likely to support it based on that, which seems frankly arbitrary. It's entirely possible that someone's gone and looked at, you know, populations, and when, you know, doctors or nurses are providing this care throughout the state, that this is an average, and okay, great. But I guess those two numbers are awfully specific. And while I understand the reasoning of the 9 hours and 20% of the additional hours makes sense, the whole premise of it being on the 25%, I find unsubstantiated at this
Yeah,
point.
I
Ms.
can't
Clark, would
speak
you-
to
Yeah.
where that lives. But what I can do is provide some additional information. If you have an adult Geri nurse practitioner that's nationally certified, which if they're billing in California, they're required to be nationally certified. They have specific adult Geri CEUs that must be completed to renew their national board certification. That's for every advanced practice RN that has a national board certification. They have specific CEUs that are required well above what we require in our license population. The other requirement that I want to share is within our healthcare facilities. I could speak specifically to acute care. I'm sure there's additional requirements out there, but within the acute care hospitals, they are required to do a age-specific competency for all RNs, all providers on an annual basis. And that does encompass the geriatric patient, but not to the extent that is in here. And then Marissa, if you have any more background.
Not necessarily background, but, and not to make it more complicated, I did check all the bills this morning just to make sure nothing had changed, but given that it is a very busy time with amendments, sometimes there is a slight delay. There has been another minor change that I just located.
Catch us up, Ms. Clark.
I know, I'm sorry, but I wanted to make sure, it's not huge, but it speaks to kind of the compliance piece. And it says for purposes fulfilling the requirements in subdivision A, which is that continuing education requirement, a nurse practitioner shall certify whether they provide primary care to a patient population of which over 25% are 65 years of age or older on a form developed by the board, and shall complete at least 20% of all existing mandatory continuing education requires in a course in the field of gerontology, special care needs of patients with dementia, or the care of older patients.
Yeah, this is very helpful. I think this is more of a bright line about what this board does and what employers do. And while I appreciate all the time we've spent on these details, and I can see how everyone's trying to work with the author and this important topic, I don't believe this is the board's responsibility and that we have the information we would need to make this decision and all of the subsequent decisions then would happen. So, I personally would prefer the motion to just be opposed at this point because I'm not seeing amendments that address the specific, central thing, which is should this board be in the position of telling nurses who have been licensed what their continuing education should be.
Board Member Patricia Nguyen.
Thank you very much. And Board Member Cormack, I completely agree with you. I also just have to say this is the worst possible venue to be writing a bill. We just don't, it's on the fly. We're reacting, it's not a great place for us to be. I agree that this should not be with the Board of Registered Nursing. It should be with employers. If you are going to ask someone to treat a particular patient population, you should make sure that they're well trained in those areas. So I would suggest, I'm not making a motion right now because we've got a lot of motions, but I would suggest that we oppose unless this bill is moved out of our purview. I just don't think that we're in a position to be able to get down to that level of detail to figure out percentages and, so that's kind of where I'm coming from.
Thank you. Board Member Neelu Patel.
I would like to restate my motion, given the fact that this is quite a sticky situation here, to indicate that I oppose this bill.
And just to clarify one thing on the bill and point about not having language very well taken, I understand it's very hard for me to just be telling you the language. It applies to nurse practitioners as well as general internists, family physicians, and physician assistants. So a straight oppose would be all across the board. So if we want to focus just on the nurse, you may consider an oppose unless amended to remove our provision. Or you could say that, to your point, that's just not the role of boards in general. I just want to clarify that the bill does speak to other professions.
I second Neelu Patel's motion. Any other comments or questions from board members? BRI moderator, please take us out to public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." President Trujillo. There are no public requests for comments on the WebEx. Do we have any public requests for comments there in the hearing room?
No, there are no requests for comments here.
Thank you. Would you like me to close this window?
Yes, please. Thank you. All right, we will vote. Dolores Trujillo votes yes. Board Member Allison Cormac,
Cormac, yes.
Board Member Jovita Dominguez,
Dominguez, yes.
Board Member Patricia Nguyen,
Win, yes.
Board Member Nilu Patel,
Patel, yes.
Board Member David Lawler,
Lawler, yes.
and Board Member Vicky Granowitz.
Granowitz, yes.
Thank you. At this time, we will be taking a 15-minute break and come back and address the rest of the bills on the agenda. So we will return back at 11:45. Welcome back. We will take a quick roll call to establish that we still have quorum. Dolores Trujillo present. Board Member Allison Cormac.
Cormac, present.
Board Member Jovita Dominguez.
Dominguez, present.
Board Member Patricia Nguyen.
Win, present.
Board Member Nilu Patel.
Patel, present.
Board Member David Lawler.
Lawler, present.
And Board Member Vicky Granowitz.
Granowitz, present.
Thank you. We have established quorum. Marissa, next bill.
Thank you. So the next bill is Senate Bill 895 by Senator Roth. This bill was discussed during our February board meeting, and the board took a watch position at that time. It has since taken quite a few amendments, so we wanted to bring it back before you all. Just as a refresher, the bill would require the California Community College Chancellor's Office to develop a baccalaureate degree in nursing pilot program that authorizes no more than 15 community college districts, with priority given to districts located in underserved nursing areas, to offer a Bachelor of Science in Nursing degree. The bill would also require the Legislative Analyst's Office to conduct an evaluation of the pilot program to determine the effectiveness of the program and the need to continue or expand the program. The bill's premise and overall intent is still the same as it was when it was discussed in February, but I'm going to go through the amendments that have since taken place. The bill now establishes that the total number of associate and bachelor degree nursing students at a community college district shall be limited to the community college district's associate degree in nursing class size as approved by the Board of Registered Nursing. It would require a community college district that is selected for the pilot program to continue to offer an associate degree in nursing program. It would provide that the community college districts that are in candidate status for national accreditation may be provisionally selected to participate in the pilot program and may commence the program upon final accreditation. It would require a community college district selected for the pilot program to give priority registration for enrollment in the pilot program to students with an associate degree in nursing from that community college district. It would expand the items that must be addressed in the Legislative Analyst's Office evaluation report, and it would extend the bill's sunset date to January 1, 2034. Happy to answer any questions.
Board Member Nilu Patel.
While I'm in support of increased education and graduation of a BSN, is there funding for this, for the community colleges to be able to do this?
So in recently following the hearings, and I think that's part of why the provision was added, that it's not expanding the student size necessarily. In talking to in watching the hearings, the author was saying what he's really trying to focus on is upskilling the ADN to the BSN type, track. It doesn't limit it to that. So that isn't necessarily establishing like a brand new program. It's creating that pathway right there. To my knowledge, that is something that they would have to cover themselves if they chose to apply for it. So again, this is a pilot program. They would come in and ask for it. And I think in asking for it, let me double check, that may actually be specified. They have to be able to cover the costs.
My next question is for EO Melby, and wondering how many extra units this would be if they do offer that, because that would be maybe an additional year, perhaps. I'm not sure.
It could. And so I'll explain kind of the process here. It really depends on how they choose to implement this. With them currently doing 20% of what we already have approved, it does not require an enrollment increase request for us. Yay. And so that allows them to implement this faster. And when we only set licensing requirements. We don't set degree requirements within our board. And so all associate, bachelor's, and master's degree programs have the same licensing requirement coursework across the board. So again, nothing that the BRN would have to be involved with on that. So essentially, when a community college would decide to implement this, if they were chosen to be part of the pilot, they would have to put together a curriculum change with us. That curriculum change would outline specifically the RN to BSN coursework that they would choose to do, understanding that RN to BSN coursework, if they do it as a separate RN to BSN option, because this only says a bachelor's degree, it doesn't say pre-licensure bachelor's degree. If they choose to continue with their associate degree and do an RN to BSN, then it would not even be under our jurisdiction because we have no jurisdiction of post-licensure nursing education. They additionally require accrediting, and post-licensure education falls under accrediting and not under ours because they already have a license, right? And so there is not an additional unit requirement that our board would require. Now, when you look at the community colleges, they have separate laws, right? They're not just under Title 16. They also fall under, I believe, Title 5. Title 5 says that an associate degree in nursing is 60 units, a bachelor's degree in nursing is, and a bachelor's degree is 120 units. So they would essentially have to increase 60 additional units in order to do this. Currently, a lot of our community colleges have a matriculation agreement to the CSUs and the UCs. They are able to complete their bachelor's degree in anywhere from 12 months to 18 months. If they're doing a concurrent enrollment, with some of our programs are, where you concurrently enroll in a community college at the same time you enroll in a CSU, then they typically complete their associate degree. And because they're already taking bachelor's level courses, they complete their bachelor's degree in 6 months. They do one additional term, and they graduate after they receive their license through the associate degree program as their initial licensure. So it's kind of this process that brings together many entities, but it depends. Now, if the community college decides to roll this out as a pre-licensure BSN program, then they would let us know they're requesting an additional degree granting option with no enrollment increase, and they would present their curriculum to us, and we would look at the entire 120 units. And we would look at that and approve that. It would come in front of our board, and you guys would vote that through or provide any provisions. Typically, and I say vote that through because typically our curriculum revisions go through as a consent agenda item. So I didn't want to say that I would assume you guys would approve, but I did want to just kind of speak to how that is typically managed.
And just to further provide, in the appropriations committee analysis, which is where impacted departments will say, we think it'll cost this much. The community college chancellor's office said there would be one-time Prop 98 general, there could be one-time Prop 98 general fund costs for each pilot district to create and implement the BSN, but they could be absorbable within existing resources. These costs could encompass updates to the new design of new nursing academic standards, new learning outcomes, updates to existing curriculum, et cetera. And then one of the pieces that the LAO has to look at and report on in their evaluation is what the program costs were for the community colleges and where they drew that funding from.
Thank you for that clarification.
Board Member Allison Cormack.
Thank you, Chair Trujillo. All right, I want to test my understanding of this. So right now, the community colleges only issue associate degrees. Okay.
In nursing.
In nursing, yes, sorry.
Yes, there are other
Thank you.
degrees.
Yes. Okay, we won't get into dental hygienists. Okay, great. So some of those students go on to CSUs to get their BSN directly or concurrently. It's sort of like this is just the first step in the process. Some of them go straight into the workforce. Yes, okay, all right. So, and is it half and half? Do we have any idea, like how, is it?
So in
I guess what
order
I'm
for
trying-
them to
Yeah.
Yeah,
the
in
rea-
order for them to get into the CSU system and work on the RN to BSN component to finish that matriculation, it's required for them to have an RN license. So we license them, they're employable at that point
Okay,
before they're getting any kind of continuing education
okay.
to get a bachelor's or master's or anything. They're employed at the ADN and they are licensed before going in and completing additional coursework.
And pardon my complete lack of knowledge about this, because to me, a nurse is a nurse. Are people who have an AA degree being paid less than people who have a BSN?
In some
No.
instances, depending on the agreement with your employer, you can get an increase on various certifications as well as an increase on various levels of education. Even if you're doing the same job, you can get kind of step or level increases based on whether you have ACLS, based on whether or not you have a bachelor's degree versus an associate degree. There's many different factors that can play into
Okay.
that, and that's employer led.
Are there jobs that require you to have a BSN instead of an AA?
Yes, school nurses, public health nurses, and typically, and I can't say across the board, typically managerial kind of roles that does not include your charge nurse. And again, I say typically because that's not consistent from employer to employer.
Okay.
And
Okay.
additionally, if you are going into teaching nurses, you have to have a bachelor's degree to be a assistant instructor.
Okay, super helpful. Thank you.
I just wanted to add
Yeah,
to that and
go ahead.
say that the trend is to have a bachelor's degree, especially as hospitals are acquiring or wanting to be magnet status. There has to be at least a certain percentage of BSN nurses within their employment pool.
Okay.
Well, and that actually was updated, Nilu. I'm not sure if you heard the new update with the magnet status. It's bachelor's degrees within administration, not the bedside for direct patient care for magnet status. So even though in the past there's been a great push for bachelor's prepared nurses, many healthcare institutions are hiring with an associate degree with a commitment from that nurse that they will advance their degree. And so that's played out. But I've been receiving lots of inquiries and phone calls as our healthcare agencies are looking at more diverse nursing population. And when they were hiring an influx of bachelor's prepared only, they were getting a less diverse nursing population. And so they are now looking at diversifying that nursing population. So they're opening back up to the associate degree level because that tends to have a more diverse population that's more reflective of the community that they serve. And then assisting them to go on to get that additional education above the level of an associate degree. So they have pulled that provision out of magnet status to require the bachelor's degrees to be in the managerial kind of aspect and not in the direct patient care, bedside, hands-on kind of aspect.
Thank you for clarifying that. I was not aware of that.
Okay.
Yeah, it's just
and then-
recently updated.
Yeah, this is helpful because, we need to have a general understanding about how this is going to affect the ecosystem essentially, right? And I guess I'd be curious, Ms. Clark, about the opposition. I'm inferring that the Office of the Chancellor of CSUs feels this would be, students then would remain at the community college to complete their bachelor's rather than moving into the CSU system where it has traditionally been. So any thoughts on the opposition to this, from them or from others that would help us understand, what we should be thinking?
Yeah, in discussions with the CSU Chancellor and then just monitoring the hearings on that, I think it is a lot of this already occurring by the CSUs and them kind of saying, well, if we need to have more BSNs, let's let the CSUs grow to accommodate those BSNs or increase our kind of like matriculation agreements. There was communication in previous versions around increasing that potential faculty resource strain, the clinical supply strain. If it is an RN to BSN program, then the clinical placements there isn't additional ones, but if they do go a full, other way, there could potentially be. So I think the main, I would say, general oversight that I would see has been, this has been something we've been doing and doing successfully. Let us do it on a bigger scale or do it better, essentially, versus kind of carving out a separate group to do it.
Okay, that's
is what I
helpful.
heard.
I guess the other thing to reflect on here is there are more community colleges than there are CSUs, and they are located in some locations that are not accessible. I mean, that, if you live in one of the more remote areas, it's, it's a hike to get to some of the CSUs.
Yeah,
Okay.
our board just approved Lassen College to do a community
Right.
college nursing. And so
yeah.
that's going to be in a much more rural area. One thing I did want to clarify that Marissa stated is if they do a pre-licensure BSN program, that it would affect clinicals. It will not, as we're limited to the current BSN, to the current enrollment level approval that they
Right.
have right now. So if they have 100 students, they would still only be able to have 100 students. 75 would be ADN, 25 would be BSN. And because our licensing requirements and our clinical requirements are the same for any degree, it has a zero impact on clinical resources at this
And
point.
The
Thank you for
other
clarifying.
bachelor's degrees that are offered by community colleges, I there's a dental hygienist one perhaps. Am I wrong?
No, I could pull it up. I believe when it started to expand, one of the kind of requirements is it couldn't be duplicative of a program that the CSUs offered. So they
Right.
tend to be more niche, kind of specialized.
Okay,
This obviously is the same program.
okay. But there are other, degrees in the medical field that the community colleges offer at a bachelor's level.
Yes, I can try and pull up some examples if that would be helpful.
While she's pulling that up, with the question about pay, it varies because our hospitals that are unionized have the same pay throughout. It just goes by years of experience and
Okay.
steps. So we have nurses that have bachelor's degrees at where I work, but they receive the same amount of pay as an ADN.
Okay, that's helpful.
And Allison, I was able to find the options for degree programs that are listed under California community colleges, applied cybersecurity and network operations, stem cell and genes technology, cloud computing, performance and production of electronic popular music, emphasis on electronic digital instrument performance, cybersecurity technology, water resources, physical therapy assistant, digital infrastructure and location service, land stewardship and sustainability. And then we have a respiratory care coming soon to Antelope. Bakersfield has research laboratory technology. Cerritos has dental hygiene. There's industrial automation. So there is a lot out there.
Yeah, okay. So the ones that I heard that are in the medical field are physical therapy, respiratory care, and dental hygiene.
There's also College of the Siskiyous is going to have a paramedicine coming soon as well. San Diego Miramar has public safety management, and sometimes that overlaps. San Diego Mesa has health information management, so that jumps in there as well. Biomanufacturing at Moore Park kind of jumps in. So there's a lot of overlaps, and then there's also individual ones as well.
Okay, thank you.
Board Member Patricia Nguyen.
Thank you. Thank you very much, Madam Chair. This seems like a pretty good idea to me. It puts an emphasis on underserved areas. It's a low-cost way to get an education for young people who live, well, not for young people, for anybody who lives in those underserved areas. It reaches parts of the state that are not, don't have options with CSU right now. Would you please remind me why we watched last time this came up rather than, support or oppose?
I think if I'm remembering correctly, it was around, and Lori, thank you for correcting me, you're right, with that provision on limiting it, it does kind of clear out any additional clinicals. I think it was because some of that language wasn't in there and it wasn't clear whether this would be a completely separate program or not, or if they'd be held to the same one. And there was concern, curiosity, et cetera, how it was going to play out, if it would be additional strain on some areas that already have kind of resource
Mhm.
lacking, faculty, clinical, those types of
Yeah.
things. But I think some of the amendments have since tried to address that.
I mean, the other thing that I like about, recent amendments is, that it pushes these community college districts to go for national certification, puts them in a better place. So, I'm inclined to support this bill, but again, would value input from other board members.
Board Member Neelu Patel.
I was just going to say, I agree with that as well. Having that option is great. I think staying put in one area is also very nice rather than having to reapply to another state university.
I agree with Board Member Patel.
David Lawler, I move to support SB 895.
Oh, I'm sorry, Vicky Granowitz, Board Member Vicky Granowitz.
Yeah, I have sort of a different kind of question. I'm wondering, given that you look at the opposition, and these are some pretty powerful organizations and schools, what are the chances that this kind of legislation will pass? And if it does pass, will it come under litigation? I mean, are you hearing any rumblings about any of that?
What I've heard is that because of these amends, there's been less of a concern, not more. Because when it limits it to its current enrollment pattern,
Enrollment
it doesn't
patterns.
take additional students, right? So if our community colleges already have 100 students and they're limited to doing a percentage of that 100, then they're not taking additional students. And with it being focused, and I believe the language put in there that makes it more where they're looking more in the rural areas, then there's not a competing CSU right there. So it hasn't gone to a support position, but I know that they're working to rectify some of those large oppositions. It's gone. Marissa, have you heard any more standing on how far if there's any more that you're hearing other than that?
No, I mean, I think the last policy hearing I watched, it was kind of the same concerns were reiterated. It will be coming up again for policy hearing, I believe, in Senate Education soon. So I'll definitely be watching to see if, the arguments are differing or change. But yeah, I haven't heard anything around concerns of litigation, but I do think from last I've monitored, the standing concerns have kind of been the standing concerns.
And the last time they tried to put nursing with this pilot, nursing was removed because of the opposition. And so the bachelor's pilot went through, but without nursing.
I have a follow-up then. The follow-up is, in some ways, it hamstrings these groups that may win the pilot opportunity to not be able to expand, while it doesn't preclude other organizations from coming into those areas and expanding or doing new schools. So in some ways, it puts them at a disadvantage. And so I just think that has to be pointed out as we're looking at doing this.
That's a great point, Vicki. Thank you for sharing that.
You want to restate your motion?
Yes. I move that we support SB 895.
I'll second that.
Okay, we have a first and a second on the floor. BRN moderator, can you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Wendy Hansbrough would like to make a comment. 1 second, please.
afternoon, everyone. I really appreciate the conversation that you are having regarding SB 895. I am the director of the School of Nursing at California State University, San Marcos, and I'm also on the board of California Association of Colleges of Nursing, both of which are opposed to this bill. While we are happy about the acknowledgement that this is not going to increase the numbers of nurses, we are still opposed to the community colleges offering a BSN. I have several points. I'll try to make the most pertinent ones, I believe, from your conversations. First of all, students can go from a ADN to BSN program without having their license completed yet. We made that change a couple of years ago, knowing that we were limiting the numbers of students who could come into our programs without a break in education. So they have to have it before they finish their ADN, but they are able to start BSN programs prior to that. Many of the CSUs and many private universities in this state have concurrent enrollment programs, as we do at CSUSM as well. These are partnerships with our community colleges. We've worked on a joint curriculum for these students, and they can begin taking BSN courses while they're still in their ADN program. And as Loretta mentioned, once they finish their ADN program and they get licensed, they usually have somewhere around the neighborhood of a semester left before they can do that. The CSUs have also made this a priority to have this be a flawless transition for students. So we have worked very closely with our financial aid officers to make sure that financial aid for these students is also a seamless process. Our programs are fully online, asynchronous. They are not brick and mortar. And so a student can enter these programs from anywhere. They do not require to be near a CSU in order to do this. Because they are online asynchronous post-licensure, we have no restrictions on the numbers of students that can be enrolled. I want to add, though, that one of our concerns is that this will be a drain on already limited numbers of faculty. We are struggling, as we are in many industries, to have sufficient numbers of prepared faculty to teach in BSN programs. This will set up a competition between other schools and the community colleges. And you may be aware that the community colleges pay a higher salary than certainly we pay at the CSUs because of where they are positioned as one of their funding from education. So we fully expect that we are going to have a faculty drain. And it may be that we also have decreased enrollment. We do know that there's a reason for nurses to have a BSN. We believe in that, and we believe in multiple pathways for students who are seeking that education as a nurse. And this is just one more pathway. And so we're supportive of the BSN, but we don't believe that it ought to be offered at the community college level. Thank you.
Thank you for your comment. Robin Nelson would like to make a comment. 1 second, please.
For sure. Hello?
Go ahead.
Okay, this is Robin Nelson. I'm on the board for the California Association of Colleges of Nursing, and I'm not responding pro or con. I just wanted a point of clarification that the information says that they are going to seek national accreditation for the nursing program. And actually, I assume they're talking about professional accreditation, which is CCNE or ASIN. Those are not considered national. National is your institutional accreditation. So I just wanted to clarify that. Thank you.
Thank you for your comment. Board President Trujillo, there are no other public requests for comments on the WebEx. Are there any public requests for comments there in the hearing room?
There are no requests for public comment here.
Thank you. Would you like me to close this window?
Yes, please. Thank you.
Just to clarify, and Lori, please correct me if I'm wrong, I do believe national is same as programmatic, which is CCNE, ASIN, et cetera. And then the institutional is regional, typically, is the vernacular that is used.
Typically, I don't know that that's accurately reflected though. So just for clarification for our board, it is specialty specific certification. And so they would be seeking specialty specific certification, which would be ASIN, CCNE, or NLN, CNEA. And those are nursing program specific. And so that certification is what will be sought or must be in place to be able to do this pilot.
Thank you, Lori.
Mhm.
Board Member Ellison Cormack.
Thank you, Chair Trujillo. So Ms. Clark, I was kind of interested in the comments from the representative from the CSU. Apologize, I was not writing down quickly enough the name. I wonder, as you're looking at what the Legislative Analyst's Office, if this bill were to pass, what they have to consider. It seems quite limited. If we think about the ecosystem, it seems quite limited to just the community colleges themselves. Have you seen in the past, would it make sense to consider impact on, the CSUs, availability of faculty? Like, what are things that we could suggest if we wanted to, in the terms of amendments that would help us help the legislature eventually make a decision on whether or not to continue the pilot? Any thoughts on how we could incorporate some of the public's concerns that way?
Yeah, I mean, I definitely think any additional key points that you think would be helpful, such as impact on other programs, which I think is a very fair thing to look at, can always be a suggestion that is included. I don't know if they limited it based on the fact that as a contingency of getting these pilot programs, the pilot programs realize they're going to have to provide data and evidence to feed the report. And so this would be surveying an outside entity, but I don't think that precludes them from trying to do that. They would just need to get that information likely from the chancellor's office that are potentially in those areas, or the CSUs in those areas are potentially the chancellor's office.
Okay, and the motion on the floor is plain support, yes?
Yes.
Okay. I feel like this is one of those things where it's possible there's some other things we haven't discussed or thought about. Is there another driver behind some of this? I see Executive Officer Melby might be nodding. Is there something we haven't discussed that, is important to our decision today?
So when I've sat in, I was actually at the CACN meeting. So both of the representatives here mentioned that they were also part of CACN. And some of the stuff that was shared during the panel is how would this affect nursing education? The positives were that greater access to the bachelor's degree. The other positive was community colleges being able to offer a bachelor's degree in the rural areas or to the underserved, more underserved population in those rural areas. And so that, to me, is what we understood as the impetus for this bill. But these other organizations, CSUs, et cetera, the same opposition that they had before was, this is going to affect our nursing programs. And that's accurate. That is one of the things that our board has always looked at is around growth, right? New campuses, new enrollment. What is the effect on the new community that you're coming into? And so one thing that I think our board can take away is these schools are already established in these communities, right? So that effect is already there. We're not increasing their enrollment or their footprint in that way, but we are changing the degree type. And so it may affect that. And I think data collection around that would be great, where the schools could report, did on the implementation of this, what was the baseline levels in that community and what were the changes at the end of the pilot. I think the other thing that we have to always understand is that it's constantly moving. Our education kind of footprint is constantly moving. You have an area that may be impacted today or not impacted today that it then becomes impacted because of the growth that we see. So even with the potential impact that a bachelor's degree offering at these established colleges have, I don't know that we would be able to directly line that to this pilot, because at the same time, we may have enrollment growth in that area that we approve with our schools that are already in that area. And because we do not look at RN to BSN programs, any in-state, out-of-state, online, hybrid at any point can increase their enrollments and their ability to offer these post ADN coursework to anybody. So I don't know that we can directly correlate that because we don't have any authority over those.
Okay, thank you.
Any other questions or comments from board members?
I
Okay.
just, this is, sorry, were there only the two individuals in public comment? Just want to make sure we got through all of the public comment. Okay, thanks.
We have a first and second on the floor. We'll now take it to a vote. Dolores Trujillo votes yes. Board Member Allison Cormack,
Cormac, yes.
Board Member Jovita Dominguez,
Dominguez, yes.
Board Member Patricia Nguyen,
Win, yes.
Board Member Nilu Patel,
Patel, yes.
and Board Member David Lawler,
Lawler, yes.
and Board Member Vicky Granowitz.
Granowitz, yes.
Thank you.
Okay, so the last bill is Senate Bill 1468 by Senator Ochoa Bogue. Just quick background, the 3-day rule that is referenced in this bill is a federal regulation that allows practitioners to dispense no more than a 3-day supply of narcotics to one person at one time for the purpose of initiating maintenance treatment or detoxification treatment. So this bill would require each board under DCA that licenses a prescriber to develop informational and educational material regarding the DEA's 3-day rule to ensure prescriber awareness of existing medication-assisted treatment pathways to serve patients with substance abuse disorder. The bill would require each board to annually disseminate the informational and educational material to the email address each licensed prescriber has on file with their board. This bill would require each board to post the informational and educational material to their website. This bill would additionally require for the medical board to disseminate this informational and educational material to each acute care hospital in the state biannually. And lastly, the bill states that DCA and the boards may consult with other state agencies if needed to implement the bill. Happy to answer any questions.
Any questions or comments from board members? Board Member Allison Cormack.
Thank you, Chair Trujillo. What does providers have not been enforcing the new DEA rule because of a lack of a comfortability mean? Like what, again, my perennial question, what is the problem we're trying to solve here?
Good question. My read of that in seeing it is, I think, I don't know if people aren't aware of that permissiveness of that 3-day. If someone were to come in, with substance abuse, that prescribing them something is allowable in certain circumstances. So maybe that's making them hesitant to do it, is what they're saying. And they want to make awareness of this provision very, very blatant. Is basically what I've gathered in looking to it, is that there's just maybe not enough awareness that this exists currently. And they want to send out more like a marketing FYI, this is allowable type thing.
Meaning providers are refusing to dispense medication?
That's good. I don't know if they would.
Or they're only, like, I mean, really, I don't understand what the problem is.
I don't know if they.
There's a lot of fear around around prescribing these narcotics, right?
So they're not prescribing, and the proponents
not
of the
that they're-
bill. Yeah.
Yeah, I don't know that they're like opposed to doing it. I think that they're worried about, if I do it,
And
what
this
is
is
the
like a
implication on my
bridge.
license?
Right.
This is a bridge. I'm
Yes.
going to give you this because it takes a few days to get into a program.
Yeah.
Okay.
And they're worried about like abuse and such that goes on with that. And if they don't get into a program,
Okay.
is this going to be used?
And do we have any data on when the BRN sends out emails, what the open rate is?
No, I'm sorry. I should not have giggled. We do not send out, we do not do anything on a read receipt. And in fact, we do have knowledge, not data, but knowledge that many don't open their emails. And if they do, it could be 6-8 months later. And there also is an issue with comprehension of the emails that go out. They may read it, and because it's from us, believe that it's saying that they're in trouble or something's wrong with their license and it's not informational. So there's a various aspects that impede our communication effectiveness.
Okay, and this would only apply to NPFs.
NPFs and nurse midwife furnishing.
Nurse midwife.
So just very focused population.
Okay, thank you.
Any other questions or comments from board members?
This is Board Member Cormack. Is the chair looking for motions?
The right motion.
Okay, then I will wait and let you make that one.
Go ahead, Board
Well, I
Member
was going to
Allison
suggest
Cormack.
that we not take a position.
Yeah.
Okay, so I would suggest we take no position on, I have to get my glasses on. Assembly Bill 2269.
Yeah, I second that. That's exactly what I was thinking.
It's Senate Bill, sorry, 1468.
No worries.
Senate Bill 1468.
Yes, that
We have
one.
a first on the floor, Allison Cormack, and a second, Dolores Trujillo. PR moderator, can you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comment. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired and will move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any public requests for comments there in the hearing room?
There are no requests for comments here.
Thank you. Would you like me to close this window?
Yes, thank you. All right, we'll take it to a vote. Dolores Trujillo votes yes. Board Member Allison Cormack,
Cormack, yes.
Board Member Jovita Dominguez,
Dominguez, yes.
Board Member Patricia Nguyen,
Win, yes.
Board Member Neelu Patel,
Patel, yes.
Board Member David Lawler,
Lawler, yes.
and Board Member Vicky Granowitz.
Granowitz, yes.
Okay, this
So
wraps
I'm
up.
going to interrupt really quick, just for some housekeeping items. Our board president is about to adjourn our board meeting for today. We will be done with our board meeting for today. The next meeting is actually an education licensing committee meeting. So the only people required to return from lunch is Dolores, Jovita, and David. Jovita, Patricia, and Dolores. David, you're free to go. And so those are the 3 people that would have to return to be able to open up and complete our education licensing committee for today. Tomorrow, we will open up at 9 o'clock for another board meeting. And all board members are expected to be present for tomorrow morning at 9 o'clock. But after adjournment today, we will only need Jovita, Patricia, and Dolores to return to start our education licensing committee meeting. Thank you.
Thank you, Lori. At this time, we will adjourn the board meeting portion of today's agenda, and we will break for 1 hour and come back to opening education and licensing. Thank you. We will come back at 1:30.